In view of the aforesaid facts and circumstances and the discussions made above, this court is of the opinion that no case for interference is made out and accordingly dismissed. It is, however, clarified that no opinion has been expressed on the validity of the BA degree of the respondent number 6 in this case, as the same was not the subject of trial.
Deeply obliged.
Yes.
May I please, your Lordship, item number 10, Lordship.
Yes.
And I may be allowed to withdraw with the liberty, Lordship, and there is one criminal case is already dismissed and I have filed the criminal revision in related law.
Item number 10.
10, Lord.
Your name?
F of.
Your name is not there. Item 10 is Rupam Talukdar.
Oh, sorry.
Yes.
May it please your Lordship, with the consent of the other said, my Lord, I beg to mention item number 48. If this matter become infructuous, this honorable court direction has already been complied with, my Lord.
Other side has been informed.
Yes, consistency is present.
Who? Yes. What is your name?
Why?
Who will record their
My Lord.
submission to be better.
No.
MS Y after learned counsel appearing on instruction of ARBIA of the ARBIA counsel submit that the order dated past indefinite, which is the subject matter of this contempt, has been complied. MSMD for learned counsel for the response submit that the order has been complied and therefore and in this regard has also placed for a copy of the speaking order dated 28/2020.
Lordship.
MS Bora accordingly MS Bora learned counsel accordingly submit that the contempt petition in view of the efforts of development contempt to yes.
Deeply obliged.
Item 48. Para copy of the order 28 between part of
Sir. I am obliged, my Lord.
Yes.
May it
May
please-
please, Lordship. In item number 66, I have filed an additional affidavit, my Lord.
please, your Lordship. Lordship, I beg to mention item number 34 with the consent of the petitioner.
I appear for the petitioner's lordship. Otherwise, this matter was fixed today. Due to some bereavement in Mr. Estimate's family, his mother expired.
not part
Mother.
Mother.
when you were
Lordship, 12 October.
12. A prayer has been made on behalf of the SK Methi as he is under bereavement. Also has the Deepura concept for the petition. Matter is adjourned to 12/10. 12/10.
Obliged.
Obliged.
May I please,
Yes.
Lordship, I'm sorry, Lordship, item number 8, Lord.
8.
I may be allowed to withdraw, Lordship, with liberty.
3F of learned counsel for the petition submit that there are certain developments for which he has instructions not press this to withdraw this writ with regard to file after.
Obliged.
Also, we have just recorded your submission. We have not even ordered.
Record.
We have recorded your submission. Let us order it first. Who is for this? Anyone? P. Sharma. Then this is present. Accordingly, since dismissed. Now, withdrawal with liberty as written.
Obliged.
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 May I please, your Lordship? Lordship, I beg to mention for listing of the matter for admission, your Lordship.
Matter of which year?
2022, your Lord.
What matter? Matter of
Regularization of for service, your Lordship.
when was it last listed?
Last posted on 24/7, your Lordship.
24/7.
Yes, your Lord.
Next Friday.
Oblige, your Lord. May I please, your Lordship? What the concern that I back to item number 33, your Lord.
33 years.
Yes, your Lordship. In this matter, additional application Mr. P.N. Goswami appear, your Lordship. Is some
Hmm.
personal difficulty. May I pray for the matter to list on 11th of October, your Lord.
Taking the consent
Yes, your Lord.
on a prayer made on behalf of P. and Goswami. Current SC EPDCL matter is adjourned to be listed on
11th October.
11 for Wednesday.
Wednesday.
Right? 11.
Oblige, Lord.
Lordship, may I please back to mention item number 5.
Yes.
So this matter may be taken up after 4 weeks. Lordship.
On the prayer of 3. Yes, inform the SC Health.
Inform I am not meet him. I'll
To
inform.
inform.
Item
But
5.
don't make a mention without informing. Informing doesn't take much of an effort on the prayer made on behalf of the petitioner. Matter is adjourned to be listed after 1 week,
4 weeks. Lordship.
after 4 weeks. 3. DP Board and Standing Council Health and Recruitment.
May I please, Lordship? I beg to mention item number 17.
Yes.
Lordship, engaged counsel out of station kindly pass over for the day. Alam on behalf of B Islam.
17. It submitted that the conducting council B Islam is out of station. School submit after 1 week.
Oblige.
May it please your Lordship, I pray for listing of a matter for order. Lordship, the matter is of the year 2022, leading to the great pay of the petitioner.
When was it last listed?
Lordship, it was listed on 19/5/2023, May.
1905.
Lordship, there is under matter which I am mentioning for listing. Lordship, this is on the admission stage, and this is of the year 2022. And Lordship, the pleadings have been completed in this.
Last listed when?
Lordship, it was last listed on 19/5 only, Lordship.
Why do you want to list it?
Lordship, because in this matter, the petitioner has been discharged from the service, and Lordship, he has been discharged without any cause, without any reasonable ground, just because he's one.
No, you want listing for what purpose?
Lordship, for that means admission here. Lordship, because the pleadings have been completed.
There are many other matters. Okay, we'll have it on Monday next. Let us see, I'll give it on Monday is the holiday. On we'll have it on 4th of October.
Much obliged, Lordship.
Yes.
May it please your Lordship, I beg to mention item 31, your Lordship. My senior counsel is having a severe throat infection. Kindly,
Mr. Kumar, it is submitted that the PD coordinator senior counsel for the petitioner is unwell and therefore adjournment has been paid for. Correct? Please after a week.
17th or 16th of October.
You cannot give a date, madam.
Yes, your Lordship.
You cannot give a date like this
Okay, your Lordship. We can-
after a week.
Oblige.
May I please the Lordship? Lordship, I have to mention item number 6.
6 years.
For adjournment, Lordship, my senior is having some difficulty.
Water resource informed or not?
No, Lordship will inform.
Madam, what is this will inform?
Try to
Read this
contact
first day in the
Lordship.
court. How many times we have to repeat this? Without consent, without information, no mention. Wait for your turn. Yes. Next.
May I please your Lordship? Lordship, I beg to mention for listing a matter for admission.
Matter of which year?
Lordship recommendation.
Matter of which year?
For 21.
21. What is the matter about? What is the subject matter?
Lordship recommendation. Commendation.
Commendation.
Recommendation.
Recommendation for what?
Master rule or
What recommendation? We are asking what is the subject matter of the list? What is the involvement in the case before this court? Why have you come to the court?
correct.
Madam, you can mention, but you have to know some fact. Don't make a mention like this. Reading the facts, knowing the facts is not that difficult. Come prepared with the facts, we'll consider. Yes,
Item number 40, Lordship,
40.
40. I will file reply with written reaction for today, Lord.
40.
40, 40. 60 days, Lord.
Other side,
Government file a very bit.
there are responsible 3 and 4. Is that Chutia for whom? You are there. Revenue is also there.
Revenue, I am not for revenue. Okay, 30.
Affidavit filed by whom?
Appointment of Gamburia, Lordship.
Who have filed the affidavit?
Government side, Lord.
So I am for a deputy commissioner, I think. The government.
You have filed the affidavit.
Affidavit,
So I don't know.
Okay, we'll
Item number.
40, 40.
on the prayer, the learned counsel for the petitioners prays for some time to file rejoinder affidavit.
I'll fix the date. I'll fix the date.
How much time do you want?
11, 10.
Please after 2 weeks
Revenue.
for to enable filing of rejoinder affidavit. Yes, next.
Okay.
Where is that order? Two orders.
Lordship, twice it was earlier rejected.
Yes, what is your new ground?
Lordship, Lordship,
London.
Lordship, kindly have a look at paras 16, 20, and 23.
Uh, 16,
20 and 23. Lord.
16 until has been quoted, then 20.
And 23. Lord.
What are your grounds? We have read this.
Lordship, there is only 2 witness examined, Lordship, and already petitioner is in custody. Lordship, as on date, Lordship, 766 days. So that Lordship create a right in favor of the petitioner, Lordship, under Article 21 of the Constitution, and there is a decision of the Honorable Apex Court, Lordship. And our High
What was the contestment? What was the contraband? How much? What is the amount?
Lordship, amount commercial quantity,
How many? How many bottles?
Lord,
1, 2, 3, 4.
Lord,
40,000 bottles
My lord.
Lord,
only.
it is 1,000.
40,000
40,000.
only. And you are saying about your length of detention.
My lord.
Lordship, length of the trial as on date, Lordship, not for
Okay, we'll have the Give him a chance.
My lord.
The NDPS
My-
bail. Third, P. L.R. Mazumdar, Learned Counsel for the petition, who has filed this petition under section 439 of the CR, praying for bail in connection with it appears that the prayer for bail of the petitioner prayers that were for bail of the were rejected by this court on two earlier occasions.
My lord.
That notice be the chairman and it is KPP Sam is present. Call for the scan copy
My lord.
of the case record.
Right.
From which court?
Lordship, it is special judge Karimganj.
Karimganj.
From the court of the special judge Karimganj in connection with what the PS case
NDPS case number 80 of 2021.
number
80 of
80 of
2021, page Lordship 22, Annexure 5.
registry to requisition the same. Let the next date be fixed when.
After receipt of
No, we have to fix the date. Day is 25th.
25th.
On 16th,
My lord.
Lordship,
16th of
obliged.
Obliged.
we will complete the motion first before the top of the list. Top of the list will try to go for a disposal.
Still not file their affidavit.
I don't have.
So these are not for ripe for hearing.
Not yet.
I don't
Right, right.
Mr. P.K. Bora supposed to file, but sudden demise of his relative, my lord, he went to Surat, madam. So I
Okay,
pray
we'll
for
grant some time in
lordship.
third. Some came under the and the third case, who is there? Third case.
Mr.
In item number 4.
Yes.
Madam, what is your name?
SR Mother. SR Mother.
As her mother. In Senate Council respect the evidence for the case. Each other
Standing council element.
Senate Standing Council,
Element.
Elementary Education Department, however, submit that some more time that due to some unavoidable circumstances, the affidavit in opposition could not be filed, for which some more time would be necessary. At least after
1 week sufficient.
2 weeks. Let it be 2 weeks.
That-
Okay, but file it
My lord.
after 2 weeks. Is there any interim order?
Lordship,
There are interim order asked earlier. Transaction till the next set of
regarding my item lordship too, they have filed their affidavit, but I should have to reply because of filing their affidavit, I could not lodge because they should have to file their affidavit.
No, in your case, you can file your rejoinder.
Lordship, because the other two matters are all are analogous, my sister matter also. They should have to file their affidavit, otherwise may some contradiction is there. So my affidavit is reply in their deed, lordship. In the meantime, I will file that. No problem.
Okay, let them file first, then
Lordship,
why we,
lordship,
if they pray for rejoinder time, we'll also get this.
lordship, lordship.
Lordship,
Lordship, any fixed date subject to convenience,
2 weeks we have said. This is the top of the list, will come before this pension.
lordship.
Yes, but
Lordship, what similar connected matter is also there. It may be paired with that matter.
see, these are top of the list matters. These are assigned to this bench. Okay, that the decision be here passed, taken, then we can have that matter text. because these have come to this bench as an assignment.
No problem.
Some difficulty.
Lordship,
You're praying for some adjournment.
yes, Lordship.
Your water resource.
Yes.
See, Sharma. Uh, a prayer for adjournment has been made on behalf of the petition. Why don't adjourn
Lordship, my senior is having some difficulty.
on behalf of the petition? So hard to reach. See, Sharma. The understanding comes water resource. The para. Matter stands adjourned by a week.
Lordship, matter may come after vacation.
Motion matter. Why vacation?
Some instruction was sought.
After 2 weeks.
But in this case, my lord, the petitioners were appointed as my lord, special police officers, my lord.
Just have you seen yourself on the mirror before you had come? Are you properly dressed?
Sorry, my lord.
Come
My lord,
properly dressed. Don't address the court.
After my lord.
Just next.
My lord, we are directed to open instruction.
Let him come.
Lordship, in this matter, the affidavit is ready. We'll
You
file
have
it.
water resource.
Yes, Lordship. Both.
Other side, none appears for the petitioner and call. Prithvi Sharma and pending water, however, submit that the affidavit in opposition is ready and can be filed and will be filed soon. Just after 2 weeks to enable filing of affidavit.
Please, your Lordship. Lordship, in this matter, we didn't receive any instruction, Lordship. So kindly notice me, will file a reply.
What's the matter?
My lord, the petitioner applied for the post, my lord, under EWS category, my lord. Earlier, my lord,
We issue notice in this. Third, NK Kalita Learned Council for the petitioner who is aggrieved by not giving the benefit of EWS category quota to the petitioner who was an aspirant in a selection process for the post of recruitment within bracket GD in different courses under the Ministry of Defense, Government of India.
earlier EWS certificate was considered. He qualified in the my lord, computer-based examination and physical efficiency test. Subsequently, my lord, while my lord, medical verification and
It is the case of the petitioner that in the initial stages of the recruitment, the EWS certificate was considered, which was, however, rejected at the time of medical exam. For the para, issue notice returnable by M. Sharma,
NN Sharma.
NN Sharma, Learned Council, appearing on instruction of K. Gopal, and this accept notice on behalf of all the respondents. That extra copy of the written served upon her by tomorrow.
God bless.
I'm sorry, my lord. My lord, petitioners were, my lord, initially appointed as my lord, special police officers, my lord.
Yes,
As special police officers, SPO, my lord.
SPO, yes. When was it?
In the year 2010, my lord. And their period was extended time to time, my lord. But suddenly, my lord, they have been dropped, my lord, and in their places, my lord, respondent number 6 and 7 have been appointed without giving any reach, my lord. On last two occasions, my lord, instruction was for my lord from the government side, my lord.
Will issue notice.
Notice to be issued.
Have you got the instruction?
No, my lord, no.
Notice. Heard 3 days from Senate Council for the petitioners who are aggrieved by their replacement as special police officers, which they claim to have been appointed in the year 2010 and now and presently have been replaced by the respondent number 6 and 7. That notice be issued returnable by 40.
I am for 1 to 5 months.
Each year, Senate additional senior government gets up on behalf of respondents 1 to 5. That extra copy of the is by tomorrow. That step to take it service of upon the by step by
My lord, one similar question is pending, my lord. Let us come up with that, my lord.
please tell along with
Resolution number 1684 of 23.
please tell along with the 1684 of
23.
2020.
Review of list.
My lord. The petitioner seeks, my lord, compulsory appointment. His father was in Piduri, my lord, and father died in 2005, my lord. Immediately he applied, my lord. Then there was no consideration, my lord. He approached this court, my lord, at annexer 12, page 12, annexer A is the this court's order, my lord. By order date 10/3/2006, my lord, which the relevant portion is at page 16. This court order, my lord, that if there is vacancy, his case should be considered with similarly situated persons, other persons. Page 16 is the, my lord, relevant portion of the order.
Let us see the speaking order of 2022.
My lord?
Let us see the speaking order of 37/2020.
Yes. Page 23. Verse 23. But here what happened? Now, along with others, he was considered. One has been given appointment in 2009. I was not given. Then a speaking order comes over that since it is 11 years now, he is not entitled. Vacancies were there. It is exhibited in the annex B itself. Second paragraph, my lord. Since the matter of appointment of has not been settled since more than 11 years in respect of series so 15 years.
You are reading which page?
Page 23, my lord.
Page, yes. Page 23, annexure G.
G, my lord. Yes.
Yes, which part?
The second paragraph.
Yes.
The only consideration is that since it in one case it is in my case 15 years, so he is not entitled to do appointment, my lord. But was it my delay? Court director, my lord, far back in 2006, 10th of March, and you also going to come to DRC meeting proceeding, annexure B, page 17.
Let us see the course direction.
Course direction, page 15 and 16. Annexure A.
Yes.
Last portion is 16, my lord.
16, yes. This was dated.
Dated, my lord, 10/3/2006.
Thereafter.
Thereafter, DLC sat on 25/7/2007.
Yes.
At annexure B, page 17. That is relevant, my lord. Also, I will come to
yes.
page 17.
Yes.
Next page. Here, my lord,
the
vacancy now in irrespective of any department, compulsory appointment can be made in any department. Vacancies were, my lord, grade 3, 55 and grade 4, 9. I am driver. Next page, my lord. My case was considered along with 3 others. Grade 3, Pardeep Vasya and Parvin Gogoi. I was GQ Taluka driver. And grade 4 1, Ranjit Boro. So, my Parvin Vasya was given appointment, my lord, kindly come to annexure E, page 21 in 2009.
But from 2006 and 9, what were you doing?
My lord?
From
No, my
2006.
no, my lord. There are correspondence. Your
Yes,
lordship can
this
see.
was the last correspondence is page 21.
Yes.
25/5/2009.
Yes.
What were you doing till from 2009?
2009, the other person who was considered with me was given. Then there are correspondence, my lord. Your lordship only come to annexure D.
Now we have read D, E, E, D.
Uh,
D is of 25/5/2009.
Yes.
And the SLC has rejected in 2021, had taken up in 2021 and rejected in 2022. From 9 to 21, what were we doing?
My lord, irrespective of the what I was doing, my lord, whether
Not irrespective. This is a read code, Mr. Sharma. Don't make that submission.
No,
We are a court of equity.
no, court
Not
of equity, I
irrespective
know,
of
my
what
lord.
I am doing.
That's
You
why I'm
made
saying.
anything, we'll admit your case.
No.
Don't think like that.
Lordship only see,
This
this
is
for
a
director, the DLC
You explain
considered,
your conduct.
and why the SLC set for a long 15
No,
years.
what did you do? Did you come to the court in time? Did you file the contempt?
No, that is there, my lord. But Lordship only see, vacancy is there, vacancy was there. Why I should have
No, the
been
entire objective of a compensation department to overcome the immediate crisis that has been taken into consideration. How do we find fault with that consideration? Yes, you may be correct. They were supposed to do at that time.
Yes.
But you didn't never raise the issue.
Both are equally guilty, my lord.
No.
Yes,
You are before this court.
Yes,
And this is a court of equity.
Yes, as well as the department, my lord,
equity.
mighty department, my lord. He is a village boy, living in a village, my lord. So,
Village boy had come to the court in the year 2006. He had that much of concern.
Yes.
He could approach the court in 2006. From 2006, there is total lack of diligence, due diligence.
even government order, my lord, you also want to say annexure C and D.
Not of it, yes.
Huh?
Not of it. Third, pre-RP, sir.
Let me for my satisfaction for the client, let them get instruction. If the vacancy exists, my lord, why not?
What is inevitable? Let it happen today.
Well, at least let them get instruction and fix the next Monday.
Not of it. Third, pre-RP, sir, in account for the petition. Who is aggrieved? Who has approached this court with regard a claim for appointment on compassionate ground. Also heard the age of property.
1 and 5.
State council could prepare the case projected by the petitioner is that his father, Bhoban Chandra Talukdar, was a driver in the office of the assistant executive engineer from a PWD Ajo subdivision and had died in harness on 2/3/2005. Whereafter, the petitioner had submitted an application for appointment on compassionate ground. The petitioner had also approached this court by filing a writ petition, which was numbered as WPC 1573/2006, wherein there was a direction for consideration of the case of the petition. Sri Sharma, the learned senior counsel has said that thereafter, the district level committee, Kamrup, in its meeting dated 25/7/2007, had recommended the case of the petitioner, which was followed by some more communication. The matter remained in that position for more than a decade and by a communication by the speaking order dated 30/7/2022, comma, the case of the petitioner has been rejected by the state level committee, which on the ground that sufficient time has passed for such consideration and any further consideration may not be in sync with the objective of an appointment on compassionate grounds. Sri Sharma, the learned senior counsel, has submitted that there being a recommendation by the district level committee in its meeting held on 25/7/2007, pursuant to the order dated 10/3/2006 of this court, comma, there was a duty cast upon the SLC to consider and dispose of the claim in accordance with law, which was not done. He therefore submits that the present case is a fit case for interference. The Chakraborty, the London State Council, however, submits that though there was a recommendation by the district level committee, comma, the matter has to be considered afresh by the state level committee, and such exercise is not a mechanical one. He further submits that the reasons assigned in the impugned order are cogent and relevant, which would not require any interference. After hearing the learned counsel for the parties, what intrigues this court is the long and inordinate delay from the date of recommendation of the case of the petitioner by the district level committee, which was in the year 2007. Delay on the part of the petitioner in approaching the court in terms of recommendation made by the district level committee way back in the year 2007. The death in the instant case was in the year 2005, and an appointment on compassionate ground is a deviation from the usual process of recruitment, where certain benefits are given to a bereaved family which has lost its sole breadwinner, and the objective is to overcome the immediate crisis. This court also cannot be oblivious of the fact that the powers exercised under Article 226 of the Constitution of India is the power of equity, wherein the conduct of the petition approaching this court is of paramount importance. In the instant case, apart from the fact that any consideration presently would not be within the ambit of the objective of compassionate appointment, comma, the petitioner has also been found to be acting in due diligence in approaching in view of the court. So that no case for interference and according to the
May I please? My lord, the petition before my lord is a 1994 APS officer, presently in the rank of SP.
Just
My lord,
your what?
I'm an APS officer, my lord, presently in the rank of SP, working as, my lord, the commandant of 10 APBN, my lord. My lord, while functioning as
Yes.
My lord, while functioning as SP, Dima Hasau, there was an incident wherein a extremist who was about to sell some, my lord, information was that he is about to sell some AK-47 rifles. He was picked up, but subsequently, my lord, in the turn of events happens that he died. And it is alleged that, my lord, he died due to police torture. Custodial death. But he did not, he was not in custody. They said he was released and thereafter he met with his death. Be that as it may, my lord, first a missing SI.
Allegation is the
Custodial death.
Your case is that he was not custody.
I was the SP, my lord. They say, my lord, it was under my direction it was done, but it was there, the officer subordinate had done it. Be that as it may, my lord, the incident had taken place.
When was it?
My lord, this incident was sometime in 2020, my lord. April 2020. Then an FIR came to be filed. First, my lord, it was under 365 missing.
FIR lodged
by the wife, my lord, of the victim. And thereafter, my lord, when the body was recovered, 302 was added, my lord.
Initially under
365, my lord. Okay. 302 and 304A was added subsequently, my lord. And the charge sheet was filed in that case
302 and
302, it's my lord 120B, 365, 302, 304A, 201, 34. 9 accused were there. I was accused number 1. And the charge sheet in this case was filed on 2/10/21.
CS file.
CS file, 2/10/21. Now, my lord,
2/10/21.
21. Page 68, my lord. My lord, the allegations therein and the list of witnesses, everything is being given there. Now, that proceeding is going on. Charge framing would take place, my lord. Now, the pre-charge framing things
That is in the Dima Hasa court.
Dima Hasa. Already committal proceedings completed, my lord. Now, my lord, on 26/9/22, 9/22, my lord, a show cause is issued to departmental proceeding. And my lord peruses the allegations in the charge sheet and the show cause. It's ditto, if I may use the word. The witnesses are the same. The documents which have been relied are the same. And my lord, there is nothing here other than the allegations that are there in the charge sheet. So, my lord, initially the copies that were given to me were not clear. So I procured those documents. Then, my lord, I submitted an application on 16/2/23, highlighting the fact that if I participate in the departmental proceedings, my hands would be open. And I said, in the criminal case, even, my lord, in the departmental proceeding, there is a...
Pay for stay of the proceeding.
I am praying for stay.
No, in the application.
In the application, yes, madam, for keeping it in advance. That application was filed on 16/2/23. I refrained from filing a written statement, my lord. No, my lord. Because if I file my written statement, I'll be opening my hands, my lord.
Yes.
And, my lord, this was replied to me on 31st July 2023, saying that you file your written statement.
Rejected. Your
Indirectly rejected. My lord, it's settled law that departmental proceedings and criminal proceedings can go on
What are
together.
your case rules?
My lord, there are, my lord, from my lord Stanton to Paul Anthony, but I'll rely on a judgment where, my lord, in the division bench, consider all those aspects and then pass them on.
Yes, to repeat, come to.
Now, what is the latest? Not latest, this case where say that for 1 year around.
My lord, that my lord's order.
Tanzan.
Tanzan, my lord. My lord followed that order.
Okay.
My lord may have paragraph
This is of the, I think, Itanagar bench.
Itanagar bench, my lord. 27. Para 27. There were, my lord, two charges. With regard to the first one, my lord, it was closed. Second one, my lord, there was a criminal case pending. And basing on that, my lord decided the issue. Page para 27. A reading of the charge memo vis-a-vis the allegation in the two criminal cases would establish that the charges are not only similar, but are based on the same material. Though acquittal in the criminal case per se may not lead to exoneration of a delinquent in a disciplinary proceeding, in the instant case, what is seen is that the charges are the same. Though the degree of proof in criminal case and in the disciplinary proceedings is different, and therefore acquittal in a criminal case may not necessarily lead to an automatic exoneration in the disciplinary proceeding, the aforesaid point was not taken up by the state. However, as indicated above, in the present case, the allegations are same. Then my lord deals with Paul Anthony. I can skip that, my lord. 28. My lord may have para 31. 30.
Yes, yes.
However, as far as the second charge is concerned, this court has observed
Yes,
that
Mr.
Yes, my lord,
First, just a minute. Where is
Lord,
the
he
order
said-
of, just a minute. Where is the order of 31-7?
31-7, my lord, 136. My lord.
136.
Let us have a look.
This showcase one.
Not the super. The,
No. 137 is that order against my lord.
by which you are directed to file.
Lordship.
130,
6, my lord. 136.
have to be the president.
My lord will have the subject, my lord.
Okay.
Show cause reply written say prior to stay drop proceedings
yes.
regarding.
Yes. Yes,
with-
Mr.
Yes, my lord, he says, my lord, parallel proceeding cannot be, my lord, go on, my lord.
No, he has not said that.
No, he says, my lord.
No, he has not said. He has not said that parallel could not be, should not go on. He said that when the charges are the same, witnesses are same, documents are same, you can proceed. But for the time being, Sanjan has said that at least when put forward 1 year as a kind of a standard yardstick, that you should give adequate time so that the criminal case comes to an end or something. Because he should not expose.
No,
be
but-
exposed.
My lord, evidence, the proof of vote in criminal and the department proceeding is different. So in 2004, my lord, this case says, my lord, the parallel proceeding, Paul Anthony is overruled. I am giving it. 2004 6 SCC, my lord, Kendriya Vidyalaya Sanstha. The says, my lord, Supreme Court says that he would 2004 6 Supreme Court Kendriya 4 Kendriya
2004, 6 SCC.
4
What is
2004 6 Supreme Court Kendriya Vidyalaya. Assistant
2004 7 SC 442
7?
SC 442 Kendriya Vidyalaya Sangathan versus T. Srinivas.
Yes, in this case, my lord, Supreme Court says, my lord, Supreme Court says that view that departmental proceeding and criminal trial could not be proceeded simultaneously is an erroneous view and contrary to established principles of law to the subject. That was, my lord, I am opposing it because, my lord, the criminal proceeding and the departmental proceeding can be go on. So this the proof of this is different. The way of proving is different. The departmental proceeding, the preponderance of the apparent malat in criminal proceeding is, my lord, has to be proved, has to be beyond reasonable doubt. So by this case, my lord, so this simultaneous proceeding cannot be a bar.
No, where is Paul Anthony says that based on the same
Yes,
proposition.
Anthony case also, my lord, the Anthony case says you cannot do.
No.
No, my lord, Paul Anthony, Captain 99 3 SCC, Captain and Paul Anthony.
Yes.
So this case, Supreme Court says criminal proceedings and departmental proceeding goes parallel is bad, and departmental should be stopped till criminal brought to a logical conclusion. That is the Paul Anthony case.
No, I don't think that's the headline you are.
Yes, my lord, against
That is the head note, I think you are reading.
against this on other cases as a 22.
No, you read paragraph 13 of Paul Anthony. That is
So-
not what has been laid down in
against,
Paul. Paul Anthony has not been
No,
overruled. There is no question of overruling. You said Paul Anthony has been overruled. The latest case is Tangent case. Tangent.
Tanzan, my lord. That is subsequent. That is, my lord, of
What is the stage in the criminal case?
And
criminal case, my lord. Now the charges would be framed.
Let us see your chart.
Lordship.
What is the allegation
Lordship.
against you as the SP?
Lordship.
Page.
My lord, it starts at page against me, my lord. That my lord would find at 111.
111.
111.
29/6/2022.
Lordship. My lord, the charge sheet date is 2/10/21. Sorry.
No, not charge sheet. We are on the show cause.
Show cause, my lord. Oh,
Charge-
allegation.
Yes.
My lord, yes, my lord.
Charge sheet we are okay.
Lordship.
2/10/21.
Same thing, my lord, in the charge sheet also. My lord will have para 1, my lord. Page 127.
127.
Lordship. 26/9/22. That's the show
Yes,
cause.
yes, 127.
Lordship. That while you were posted as superintendent, Dima Hasav, Santosh Ojai, that's the victim, my lord, an erstwhile cadre of so-and-so and resident of so-and-so, was taken away forcefully from his home at around 6 p.m. by a group of armed persons in Bolero vehicle. After that, as per your direction, he was taken into custody by so-and-so near Boat Lake, Haflong. Sri Santosha was taken into the office of superintendent initially, then to a location at Jatinga, and finally to police guest house at Haflong. Santosh Ojai was questioned and physically tortured by you. And other police personnel, resulting in severe injuries and bleeding from their mouth. No entry was made in the journal diary before and after the detention of so-and-so. His family members were also not informed about his detention. The illegal detention of so-and-so, physical torture, resulting in death of detainee without due process of law under your direction and command tantamount to serious misconduct on your part, and provided by the Constitution of India, the Code of Criminal Procedure, the guidelines of Supreme Court in D.K. Basu, provisions of 47A so-and-so Assam Police Act. In this regard, therefore, you are charged with serious misconduct. Then my lord may have, just for a sake of my satisfaction, 5, my lord, at page 128. That
Here are the pages.
128.
Yes, 5.
5, my lord.
Here
That
the
while
pages.
you entered into a criminal conspiracy.
But you have told the pages of GTN.
Lordship? No, not me, my lord. There is an allegation that GD entry papers were drawn, my lord, destroyed by my subordinates. This is what I was trying to, my lord. That while you entered into a criminal conspiracy in connivance with the police officials, namely, this is the FP so-and-so, to tear the pages of so-and-so, which had been inserted in connection with so-and-so. My lord, this is the same allegation there. So, my lord, this will require a proof. This is a complex question, my lord.
But the allegation against you is not only a vicarious liability, but there is a direct allegation against you that you had physically tortured.
But that's it, my lord. But my lord, that again, my lord, will have to see.
Why we are seeing, because if we are considering your prayer for interim order, we have to see what is the
Lordship,
allegation against you.
Lordship would have the allegations against me in the, my lord,
Now here there is an allegation of
physical
physically
torture.
tortured by
Lordship.
you.
Lordship,
It is not that under you.
no, my lord. Page 112, if my lord comes to the show cause,
112.
1111 it starts.
Yes.
Charge sheet, my lord.
Yes.
My lord will have so-and-so. My lord will have 2, my lord.
At 111.
2, my lord. 112.
112.
Lordship.
2, number 2.
Lordship.
On reaching.
On reaching the residence of so-and-so, they proceeded to Haflong. So-and-so over phone being so-and-so to his residence. So-and-so was brought to say, and then Superintendent of Police was staying. So-and-so interrogated the victim and again tortured him. The so-and-so took AK-47 of so-and-so and folded, but so-and-so assaulted so-and-so, was bleeding from the mouth. Later on, so-and-so, along with so-and-so, brought the victim so-and-so and kept him in. All these happened as per direction and in presence of so-and-so, then Superintendent of Police Dimahasa. My direct torture is not there, man. But in the show cause notice, they have gone beyond that, man. And what my senior friend is saying, my lord, it's true. A department proceeding and a criminal proceeding can go on. But here, if it is based, rooted on the same thing, my lord, it would be difficult, my lord.
Even same thing also, my lord, that can be. My lord, 2022, the case, so I have gone through it, my lord. My lord, same evidence, same practice, that can be also. Well, my lord. Yes, I am. 2022 2 GLT 252 Gulab Sharma versus Union of India. The Department of Proceeding so and so is can be followed the same facts of same evidence.
I heard three UK and Ireland senior counsel. With by
HK Hospital.
so that's your name is not by
Should have
been there,
He filed it. Mr. N. Sharma.
Or
Mr. N. Sharma, my lord.
NK Sharma.
NK Sharma.
I'm sorry, my lord, I'll just take up.
clear. To defend it. Was it filed by some other set of counsel?
Niranjan Sharma, my lord. Nikunja Sharma, sorry.
For some other counsel. No, first this.
This is of someone.
Someone else had come in, my lord.
No, the name is the same petitioner.
My lord would have the.
No, it's okay. Inside
Lordship,
the papers.
that's true, my lord. B. Vikram Gogoi, State of Assam, H. Agarwal, J. Singh, so and so. But my lord,
error in writing
the
advocate's name.
but my lord will have this one.
Same advocate clerk.
Some
Yeah, for this one.
It appears.
handwriting also appears to be sick.
Because getting out till High Court. You are getting all this thing.
But inside the check slip there, it's true. He will do. He will do. Agarwal, Takarwal, so select about engage story probably. I'm sorry, my lord. Well, I'll
But
pick up with the rest.
UK and Ireland senior counsel. No, senior counsel name we are not picking. But at least somebody from record has been, nobody was there.
Lots of true, man. I got it, man. I got it. I got what? Totally different set, man.
Will not say from any rival group. Maybe you are on the same boat. You thought maybe change of strategy or something. Heard UK and Ireland senior counsel tested by H.K. Das for the petition. Good topic. The petitioner is presently posted as the commandant of 10 AP battalion. Where is it?
Kahilipara, man.
At Mohan. Good topic. He is facing a criminal case which was initiated by filing of an FIR in the FIR leading to registration of Harangaza PS case number 3 of 2020 under section 365 class 302 class 120B and 201 IPC. And the state criminal case is at the stage of, and in the state criminal case, investigation is over and charge sheet has been filed on 2/10/2021. It is the case of the petitioner that based on the same charges, a departmental proceeding has been initiated by issuance of a show cause notice on 26 9/2022. So, that's the senior counsel for the petition has submitted that the allegations in the show cause notice and those which are discernible from charge sheet are the same, and the witnesses and the documents are also identical. Accordingly, on 16/2/2023, the petitioner had submitted an application to keep the departmental proceedings in abeyance as filing of a charge sheet, filing of a written statement, filing of a statement of defense in the departmental proceedings would cause prejudice to him, as he will have to expose his defense. However, by communication dated 31/7/2023, the aforesaid prayer appears to have been rejected, as the petitioner has been directed to submit his written statement. Sri Nair, sir, Sri Nair, the Senior Counsel, submit that while there is no dispute to the proposition of law that a departmental proceeding can proceed simultaneously with a criminal case, and there is no absolute bar, in the instant case, since the charges are the same, further participation of the petitioner in the departmental proceeding by submission of statement of defense would cause immense prejudice to him who is an accused in the criminal. Relying upon the case of the Honorable Supreme Court in Kansas versus the Senate Council, Senate Council submit that it's the state case of the earlier cases on the field, including the case of Captain Paul and where have been discussed, and a direction was given for keeping the department of event the event where the charges are same for a period of a year. He further submit that the case of M. Paul and Tony, the Honorable Supreme Court has explained that the standard of proof in a criminal reserve a department of being different, there cannot be an absolute bar for federal, which, however, would have to consider on the fact circumstance of every case. Yes, they run it. It should run it. They're going to get some petition has submitted that there is no bar in parallel proceedings, and in this regard, he has also tied up the case of KVS versus East University, reported 2004, 7 is 444. If further substance that the charge are serious nature and therefore no interference is made, that notice should be returnable by 6. It should hear the learned state now, except note on behalf of
All the
all the respondents. That extra copy of the petition served upon the state learned state now by the court. What is the present state?
Where, madam, in the demand proceeding, nothing has moved, madam.
Para the Spinaya learned senior council raised for an interim order and has submitted that till now the statement of defense has not been filed has not been submitted by the petition, and unless there is an order of case of Department of Commerce, irreparable loss would be suffered by the petition. That to consider in consideration of the fair interim order, this court has examined the charge sheet dated 2/10/2021 and the show cause note dated 26/9/2022, from which it appears that the charges for the petition are almost identical. This court has also been informed that the witness and the documents relied upon by the prosecutor and the department are the same. Taking into consideration the law laid down by the Honorable Supreme Court, including the one past of tension from a direct that did that further in the department procedure initiated by the Super Note 26/9 shall remain suspended. This court, however, makes it clear that there is no restriction on criminal, and rather is expected that the criminal should take an up.
Lordship. Could you type it down? Type it. Much obliged.
May pleasure.
Yes.
This petition is preferred for non-declaration of the result. Lordship, what happened in this case on 4/7/2022, Lordship, an advertisement was issued for fill up the post of Anganwadi worker under various Lordship center.
There are anomalies, I think.
Yes.
In your examination. Which district?
Lordship Jorhat.
Jorhat? No.
Jorhat.
Yes, what?
Other Lordship, other center result declare only in respect of that particular
So in
center.
one of the districts there was some anomaly. That was the submission.
I will have to get the instruction.
Get instruction. Third, MSP Bhattacharya Senate count. For how many of you are there?
Only one.
Only
One petition.
Yes.
For the petition who is aggrieved by non-declaration of the result of a recruitment process initiated by advertisement date 4/7/2020 for filling up 62 numbers of posts of Anganwadi workers in various centers under the Northwest Jorhat ICTS project. The learned counsel submits that pursuant to the state advertisement, the petitioner who claims to be eligible had participated and appeared in the interview held on 15/10/2022. However, no results have been declared with regard to the state recruitment process.
My lordship, in respect of other lordship, that result,
Unlike the other centers,
only one center lordship, that is Guakula,
that is not declared, has not been declared so far as
Gorakua,
so far
Anganwadi
as
center.
the center in which the petitioner had applied, namely what?
Gurakula,
Namely
number one Gurakula.
Gurakola Anganwadi Center under 47 number Dokhin Porbutia Gaon Panchayat. He further submits that the results for other centers have been declared.
Yes.
That notice be issued, returnable by 4 weeks. Yes, for all previous other calculations except note on behalf of all the that extra copy of petition served upon the hazard by note.
Only now social welfare, it has become split into two different. Here it is response number 1 and 2 is given as Department of Social Welfare, Director of Social Welfare. That's
Empowerment now.
now it is Women in Child Development.
Oblige.
Make this. The petitioner before your lordship is a physically disabled person, my lord. Pursuant to a valid selection process, my lord, he was selected for appointment as a LDA against backlog reserve post of persons with disability.
Okay.
If your lordship kindly turns to page number 26, my lord.
Yes, then what has happened?
26, your lordship will see the appointment of disabled person. It says, sir, I am directed to enclose herewith 5 applications received from applicants mentioned below, requesting for appointment against backlog of reserve post for disabled persons in DRDA, and to request you to take necessary action in this regard from your end.
Third, learned counsel for the petition. The petitioner who belongs to the category of PWC had participated in a recruitment process along with others and was appointed on 3/9/2010 as LDA in the Gototrapa Development Block, Nagaon. It is the case of the petition that while other persons who were appointed along with the petitioner were placed under the old pension scheme, the petitioner has been placed under the new pension. That notice is returnable by 4 weeks. Yes.
Here
PNRD.
What ask for?
I am for response number 4.
I am for 5.
Lordship.
1 to 3.
PNRD 1 to 3, my lord.
PNR. Standing on PNRD for responsible 1, 2, and 3. 4.
Lordship.
RM for standing council. And yes, already state council press. Right?
Lordship, our name is scientific.
That the names of standing council. Social
Justice and Empowerment Department.
Justice and Empowerment Department. We respect.
And may I pay a copy of the
I'll give extra copy. I'll give extra. I'll give.
Already said.
Oblige.
May I please, lordship?
Yes.
My lord, petitioner, my lord, belongs to OBC category candidate, my lord. He participated in a recruitment process for Central Armed Police Force, my lord, and he did not avail the benefit of reservation during the recruitment process. So he can be selected under your category, my lord. And he petitioner obtained the more marks than the last selected candidate of your category, my lord. But he has not been given.
Otherwise, you belong to which category?
OBC category, my lord.
But
Similar matter.
you did not avail the benefit.
Yes. Similar matter, your lordship already heard. Lordship notice me because vacancy position has to be.
Will issue notice it, Lordship. Third creator of it for the petition who was an aspirant in a recruitment process for recruitment process initiated by advertisement dated 21/7/2008 for the post of constable at a GD in the Central Armed Police Forces. So, and it is the case of the that though he belongs to the OBC category, he did not avail any benefit, public exemption under the state category, in spite of secured marks more than the last select candidate, that unreserved category, he has not been appointed. For all
Lord.
copies by should we list along with pending? This is pending. List along with WP 5092. Give extra copies by tomorrow.
Mayor, your lordship. Lordship, an advertisement was issued for filling up the post on for the persons with physical disability, lordship. Lordship, at page 23, your lordship will find my certificate.
Yes.
The disability is to the extent of 40%. Down below, lordship will see, and this lordship, this certificate has been issued by the member district disability board, medical board. It is a board which has been duly constituted under the Persons with Disability Act 2015, lordship. So this is a certificate.
Your certificate has not been taken into consideration.
Not been taken into consideration, lordship. My case was rejected by directing us to appear before another medical board, which was formed by the state government, by ignoring the fact that this certificate has never been challenged by anyone. This certificate has been issued by a competent authority under the board.
PM task. You're not there on record.
Lordship, I am appearing for NJ Khatania, lordship, with out of station, lordship.
M. Suspended counsel has appeared on inspection of NJ Khatania, suspended counsel. The petitioner, who is a person in the category of PWD with 40% hearing impairment, was an aspirant in a recruitment process for various posts of grade 3 and grade 4, initiated by an advertisement date 30/12/2019.
18, Lord.
Huh?
30/12/2018.
Not 19.
Where page 25, Lord.
I have written 19.
Some typographical error, Lord.
30/12/2018. The petitioner claims to have figured here at serial number 90 in the select list pertaining to the transport department and was directed to appear before a medical board. The medical board had, however, rejected candidature of the petition by holding that the certificate pertaining to PWD of the petitioner was not acceptable. That is a categorical case of the petition that our certificate was not subject matter of health in an proceeding and was not used, and therefore such disqualification has not been done in accordance with law. Where is the disqualification?
The disqualification was verbally informed, Lordship. There is no disqualification order as such.
In the main the select list, your name is not there.
In the final select list, the name is not there, Lordship.
So he's
It is informed that though such disqualification has not communicated from, it is discernible as the name of the petition is not there. If you find it, select list. When was the final select list published?
it was 21, 20.
Lordship, 19/12/22. Lordship, a statement is there in the
22.
petition, Lordship, but we have-
Late, Mr. Das, but late issue notice. Almost a year you are coming.
no, Lordship,
Notice by issue, my lord.
no, Lordship, the final medical, we were called for medical, right? Notice dated 27/7/2023.
Okay.
That
is-
notice be issued, returnable by 4 weeks. Please return it. Additional,
I am for 4, my lord.
what about one
Only
social
for-
empowerment, RM plus, standing of social justice and empowerment department. picking up on. For response number one, and
I for
Mr. Das, anyone, only for one.
Only one.
Madam for MS Country Board Standing Competence Department. Correspondent number 2. CP Board
Thank you.
State Standing Competence. Each and every department for number 3. 4 and 5. Oh no, university is also there.
University.
4 is
I am
the 20th. And 5 PJ Standing Council for 182 to 5. That extra copies be served.
Lordship, may I pray for order, Lordship, that one post may be kept vacant.
Now,
no, my lord. Now, my lord.
if you are successful, then
So then another order has been passed, Lordship, by this honorable court in WBC 3793 of 23, where it is stated that any appointment made under the category of hearing impaired disability under the that particular department, water resource department, shall be subjected to the outcome of the repeat dinner.
Facts and
no,
Lordship,
see,
the same factors.
Here, my lord,
Mr.
he
Das,
has not submitted all
Mr.
these
Das,
things.
you have to compete with persons in that category.
Lordship, this is the only.
Only because you belong to that category, your appointment is ensured. That is not the thing.
Lordship,
The
understand.
competition will be confined with the persons belonging to that category.
Lordship,
Now, only because you belong to that category. So tomorrow, if you come to the conclusion that your rejection has been done erroneous,
Lordship,
but still you have to compete,
Lordship,
and the other candidate will be better than you.
maybe Lordship. That's why Lordship, it is stated any appointment made shall be subjected to the outcome. May I pray for the similar order, Lordship?
Final select is prepared and published by the governing body. It was dated 31/1/2023.
2019.
But the base
Appointments made or not?
Appointment
Mr. Bhatia?
not yet made, Lordship. As per my
Lord,
instruction, not yet made.
Okay, we'll see. Any appointment, any appointment.
more than 300
Appointments have been made,
have been
Lordship.
made.
Appointment has to be made, my lord. Then no.
If you make out a case, last person may have to make way for it.
Lordship, that is what was provided in the order I just
Since
gave.
the appointment has been
Lordship.
Lordship,
Lordship,
Moreover,
similar cases, Lordship, item number 20, 21 and 23, Lord.
18,
what is the disability?
18.
18 to 19.
Similar matter 18, 20, 21, 22, and
Lordship, in 20, the extent of disability is 80%.
Mr. Das, you are in this matter.
Lordship, I will be appearing on
Can you-
paper.
can you give a-
Lordship, I will provide a list, Lordship.
Just item number, what is the disability?
Lordship,
And the ground is the same.
ground is the same in for all, Lordship.
I just want the item.
Lordship, item 16 I have already placed, Lordship. Item number 20, 21 and 23.
And respondents are same.
Respondents are different, Lordship.
No,
In item number 20 is the Health and Family Welfare Department. 21 is also the same department. 23 is the Irrigation Department.
but I am for respond number 4.
23 and irrigation. So tell us,
20 and 21 is the health and family welfare.
social welfare is there?
Social justice.
Social justice now.
Guwahati University is there?
Guwahati University is there in all.
Why Guwahati University?
Lordship, because the exams were held by the Guwahati University.
And transport?
Transport is only in item number 16, Lordship. I will provide a list. Lordship.
Lordship, moreover, in item number 16, the petitioner has written that social justice and empowerment department is represented by secretary. It's not secretary, it's being principal secretary. May I pray for a copy of the petition?
Yes, they will give by tomorrow. All the cases.
Our name may kindly be reflected.
In all the cases, you are there.
Lord.
Name of sending council should reflect the council.
Lord.
4 weeks to turn April. 4 weeks.
4 weeks.
This fellow
Up to 23 meters. He appears for
and other matters who appears. There are other matters.
Yes, my lord.
Mr. Roy, you are appearing.
Yes, my
Which
lord.
matter?
I am item 18 and 22, my lord. My humble submission, my lord. My lord, your lordship has
What is the disability?
my lord blind.
You write a piece of paper. Same case.
Same case, in one case in 18 blind and in his hearing impairment in 22, my lord.
Just write on a sheet of paper.
My lord.
Try to give a sheet of paper to the to our.
Yes, and another thing, my lord, I might be placed, my lord. There is a recent Supreme Court judgment, my lord. Your lordship has said that the discrimination between the disabilities, my lord. The point actually, section 3 of the right.
No, those merits will consider. Right now we are issuing notice. We are not saying anything.
If my lord, the post are reserved for the disabled person, my lord. If this post are filled up by subsequent advertisement, then we will be out, my lord. So therefore, my lord, the post shall be reserved or the outcome of the repetition, my lord. Because some
No, if there are persons in the same category, how can you prevent those persons from being appointed?
They are not made part.
but the vacant post which will be not filled up.
So why not filled up? Are you the only candidate in that category? You are not the only candidate. In your category, you are only competing with similarly situated persons.
Yes, my
Your candidature has been rejected, doubting your certificate. There are other candidates.
not doubting. My re-verification of the incapacity, my lord, by a procedure which is not known by under the end.
Understood, but aren't there persons in your same category?
Yes.
The vacancy, the post which has been advertised, that would be filled up only by persons in that category.
Yes.
You cannot prevent somebody else's. Now, if you succeed tomorrow, the last person may have to make way for you.
But the Supreme Court says the equality, though there is no specific provision in the Act, the equality vis-a-vis non-discrimination vis-a-vis the disabled persons, my lord. It should be it should be read as the non-discrimination vis-a-vis the disabled person, my lord. My lord, kindly see the Supreme Court
Well,
has
consider, you have understood your problem.
You place it
Will
on
consider.
hearing.
You cannot restrain somebody who is.
because the government has initiated a process, my lord. That is actually under section 3, my lord. That is the proportionality.
Mr. Roy, have you understood that in your category there may be other candidates? Your candidate has been rejected for some reason. So for some reason, we will consider your case.
But
now you have to compete with other persons of the same category.
But we have been selected. The persons, those who are selected, among the selected candidates, there has been discrimination on the ground of disability. That is not permissible in the law.
Now, if we uphold the rejection, where is the question of discrimination? If your claim tomorrow, if we uphold that your claim has been rejected on cogent reasons, where is the discrimination? You are raising the question of discrimination. We'll examine it. Yes, next.
Obligation.
Give the detail. The number, the category, which case number, and who are the respondents in your.
My lord, there's a higher education in 18.
Item number?
Item number 18, my lord.
Higher education was there. Higher education, anybody? Deep woman. And who else?
I am for 4.
No, that will. Social welfare is there. Guwahati University, health, and in the other one, Mr. Roy?
My lord, right in higher education.
Item number?
18. Yes, higher education, joint right to health service, police.
No, my lord, in ITM, sorry, in technical higher education, both higher.
Do you? Okay. Huh? Yes, give the percentage of disability and the category.
My lord, in item 18,
Put right in a sheet of paper what
Yes,
Mr. Das is doing. You do it. Give it right now. Nampura.
May please, your lord.
Nampura.
My lord, a week back, my lord, lordship has disposed
What
of
about
one.
the appeal?
My lord, nothing has been done, my lord.
No, have you filed the appeal?
My lord, yes, my lord.
When? Is it filed before the present authority?
My lord,
The principal secretary of
yes,
the
my lord,
department.
Annexure 12, my appeal, my lord.
You filed?
Yes, my lord. Annexure 12 is 25.
this is a representation.
Yes, that was to be disposed of, my lord. And
Item number, page number?
page 65, my lord.
Is it before the appellate authority?
No.
My lord.
Mr. Doctor?
No, this is a representation before the
He's not
deputy
deputy
commissioner.
commissioner, he's not the appellate authority.
My lord,
Appellate authority was the divisional commissioner, now there is a change. Now the principal secretary of the department.
Yes.
In other cases, we have been taking a lenient view that giving you a scope to again reproach the period of limitation will not run. But
Well,
your this election is of long back.
my lord, in the
Selection
meantime,
of,
my lord,
I think
in the meantime, my lord, they have published the select list, my lord.
when?
My lord, Annexure 68, my lord.
Well,
On
you have,
3/1/2023.
you have to prefer an appeal.
Yes. My lord,
If you prefer an
yes,
appeal, we'll give you liberty.
My lord,
as per his affidavit, he has completed 27 years. For appointment of Gambura,
you have
age
challenged.
is fixed on 30 years. So
My
he
lord,
has not
We
completed
have challenged the age criteria, my lord.
But then
Stipulation
we'll-
of age
then
criteria.
we'll have it. Third 3 years done it count for petitioner who was an aspirant for the post of Gambura.
Pursuant to advertisement, page 33, my lord.
Gambura in respect of charge number 25.
25, my lord.
Charge number
Under-
25, comma, village Architana in the district of Borpeta. Full stop. It is the case of the petitioner that the petitioner has not been disqualified in terms of a gazette notification dated 26/8/2021 and the collision term dated 27/10/2022 regarding the age of eligibility. That notice be issued, returnable by 40. Doctor for
one.
PS Doctor, the Training Council, Revenue Department, one, and 2, 3, and 4, Chakraborty, extra copy of that have taken for service on the by Mr. Goswami, which matter? Motion matter? Which matter? Admission matter?
Well, the matter pertains to appointment of grade 4 post, my lord, in the establishment of presiding officer labor court, my lord. Page 32, my lord. Kindly see the advertisement, my lord. Page 32.
Yes.
I have applied for 3 numbers of post, my lord. P1 to PO, P1 to register, and night secretary, my lord, by means of 3 separate applications. But the selection board took 1 interview, my lord, but marks assigned to other posts also, my lord. That is my case. After filing of this writ petition, my lord, one document I obtained, my lord, for which your lordship allow me to file an additional affidavit, my lord. They took interview, but as per this document, my lord, government instruction, my lord, at page additional affidavit, my lord, kindly see at page 68, my lord. As per this instruction, my lord, reference portion, my lord, kindly see discontinue holding interview for grade 3 and grade 4 posts, and later issued thereof dated 25/5/2016. That is page 67, my lord. Kindly see. As per this instruction, my lord, to discontinue the process of interview for recruitment of grade 3 and grade 4 posts, my lord. My case is that, in my case, my lord, I have applied for 3 numbers of posts. They took 1 interview, my lord, but marks assigned to other posts also. Paragraph 10 of the writ petition, my lord, kindly see, my lord. After filing of this writ petition, the said instruction I obtained, my lord. Therefore, I have filed this additional affidavit, my lord. So they cannot.
There was no written test.
No, my lord. That is the facts of the matter, my lord.
Yes.
And this notice, Lord.
Certification when it comes for the petitioner. The petitioner had applied for 3 different posts, which were the subject matter of an advertisement that is 14/12/2022 issued by Office of the Labor Court, Dibrugarh. He submitted that the selection consisted of only 1 interview, where marks were allotted for all the 3 posts.
Yes.
He has also brought the notice of by way of an additional affidavit dated 11/9/2020 that recruitment for grade 3 and grade 4 posts should not be done on the basis of interview, as there is no requirement of any assessment on the personality. That notice is issued, returnable by 4 weeks. The H. Chakraborty, for all the respondents,
1 to 5, Lord.
1 to 5, extra copies, more to for service of notice upon the respondent number 6, 7, and 8. Be taken into set for state as well.
Obliged.
May I please, your lordship?
Yes.
Lordship, I am Anganwadi helper, lordship. I have promotion or upgradation for writ petition file, lordship. Lately I get lordship appointment letter, lordship. There will be there have second petition file. Kindly issue notice, lordship.
You have not understood. You have obtained this appointment letter of Mr. Ahmed.
Lordship.
You are appearing for the notice yet to be issued. Notice not yet issued. How do you appear?
Earlier there is a writ petition, my lord, where I am appeared, my lord. Item number 63, my lord.
63.
Now they filed, my lord, a writ petition challenging my appointment, my lord. That copy also is not given to me.
63 notice has been issued.
Yes, my lord. That is earlier. What happened, my lord? He produced a, my lord, fake documents of 9 pass certificate, my lord.
No, lordship.
And my lord,
Okay.
director of, my lord, notice maybe.
Your enrollment.
Yes, Lordship.
Third member of that is found for the petition who is aggrieved by by the non-consistency of the case of the petition for application from the post of Anganwadi helper in the 105 Mohia Anganwadi Center in the district of Barpeta to the post of Anganwadi worker. He is also aggrieved by the appointment of the number 5. That notice be issued to enable.
I'm
Yes,
one,
social,
yes, I'm 1 to 4.
1 to 4.
1
Social empowerment support can appear.
social justice empowerment we are
This one will come under. This one is.
Women and child development.
I think Mr. Chutia, you can appear.
Yes.
Speak for 1 to 4. And Ahmed, you are appearing for 5. Teacher Ahmed, council notice on behalf of person number 5. Parallel stock of Internet Council
DPF.
published along with WP 4619 of 2020. Published. Yes, Ahmed.
Regarding my lord, appointed as a Gabura in 2011 of Trade Revenue Villages, my lord. While rendering service, my lord, he was arrested on 13/5/2021, my lord, in connection with a criminal case, my lord. Then he was released on bail on 2/8/2021, my lord. While detaining in jail, my lord, without, my lord, initiating any proceeding against requirement inquiry against him or not suspending from service on 19/7/2021, governors of other villages.
You have not been allowed to take charge.
Yes, they take him. My lord.
Any instructions you have?
My lord, we have received instruction, my lord, on
Let us issue notice.
the notice was issued, my lord. This instruction is not complete.
Or
My lord, in the Malay, where my lord direct the deputy to dispose of the petition, direct the deputy commissioner. my lord.
we have here Ahmed Senate Council for the petitioner who is petitioner. It is the case of the petitioner that he was duly appointed as the Gampura
Of Trade Revenue
of
Village.
Free Revenue Village
Yeah, my lord. Under
and footstep villages. However, he was arrested in a criminal case in which he was granted bail. To the appointment as Gampura of the petitioner has not cancelled, the respondent number 4, who is the government Gampura of another village.
Yes,
has
sorry,
been-
my lord. Not response number 4. I am not very particular in this case. Some other.
no, the authorities have allowed a government Gampura of another village to
Look
look
after.
after the charge of the present post. That notice should returnable by
4 weeks.
4 weeks.
And for 2, 3, and 4 matter.
1
1 for revenue.
for S. Dot. 2, 3 extra copies. There are pending shall not be a bar for consideration and disposal of representation of the petition said to have been filed.
Yes, on my 9/5/2022.
Representation dated 9/5/2020.
22. Put out respond number 2. Right.
May I please, madam? My lord, this is with regard to a selection process initiated by the Director of Medical Education. My lord, there were some grade 3 posts, including a post of driver. My lord, this petitioner, while my lord marked in all the 4, but she did not have any driving license or driving experience. Be that as it may, my lord, there was a joint examination for all these posts. She cleared the written examination, and the results, my lord, would find at page 23, my lord.
Yes.
And they were asked to appear for a skill test and document verification in the Gaudy Medical College. Her name, my lord, is under the post driver at page 24. 25, my lord, would find.
You were appointed, but they are considering as a driver.
But what happened, my lord? When the skill test took place, there was no skill test, only document verification. I clarified that I don't have it. But still, they selected me as a driver, and I was appointed, my lord.
Okay, Heard you can and for the petition pursuant to selection process for various non-technical grade 3 posts, the petitioner, who was an aspirant, had marked her option for all the posts, which included a post of driver. Since the petitioner did not have a driving license, she was under the impression that her candidate could be for the other post. However, by an order 25/5/2023 issued by Director of Medical Education, Assam, the petitioner was appointed as a driver, which, however, on verification was found that she did not.
No, when she went for joining, her joining was kept in hold.
As a driver. Since the petitioner did not have a valid driving license, he was not allowed to join the post, and according, the petitioner had submitted a representation to change her posting from driver to any other available grade non-technical post, as the recruitment was a common one. However, no action has been taken till date. That notice is returnable by 4 weeks.
Lordship, here the only issue is, Lordship. Lordship, here is the only issue is that the Director of Medical Education has not been made a party, Lordship. I'm appearing only for 1 and 3, Lordship. There is no such post as Director of Health Education, Lordship.
My lord, I'll implement him. I'll file an appropriate application. It's my mistake.
D. Upamanyu, Standing Council, Health and Family Welfare Department, while accepting notice on behalf of respondent numbers 1 and 3, submit that the respondent number 2, that there is error in describing the respondent number 2. Period is comma. That notice is returnable. That is stock of the recently served the Standing Council. The Standing Council praised for and is granted to file appropriate application for a correct description for correctly described the respondent number 2.
Sorry.
Obliged.
Made to you, Lord. Lord, the petitioner before your lordship, he was working as a sub-inspector of police, my lord. What had happened, my lord, that there was an allegation that pursuant to an order of ad interim anticipatory bail granted by this honorable court, my lord, the petitioner did not record the statement of the accused therein. Now, my lord, actually, what happened? This honorable court fixed a date of 23rd. On the contrary, the
accused in the other case, my lord, he turned up on 26th. That's why he said, unless you get it extended, I will not do. Anyway, he then filed an application before the, my lord, Vigilance and Anti-Corruption, where an allegation was made that I have demanded money for sending CD and all these things. Be that as it may, my lord, by laying a trap, a constable was arrested, my lord, where from a sum of rupees 6,000 was recovered. Subsequently, petitioner was also arrested. Subsequently, he is released on bail. In the meantime, my lord, a disciplinary proceeding was initiated against the petitioner. Now, after following suspension, show cause notice was issued on 16/6/23. Then, my lord, the petitioner submitted his reply to the show cause notice.
You have been dismissed.
No, my lord, I am sought to be dismissed. Now, my lord, the inquiry report is also there. Please come to page 58. The operative, the main portion is in page 59, my lord. The inquiry report has not been given to me. What has been given to me is an extract of the inquiry report. If your lordships could notice that page 59 towards the bottom, extract of inquiry. Now, what had happened, my lord?
Page 59.
59.
Bottom.
Bottom, extract of inquiry. Now, my lord, what had happened? After this, my lord, I have been issued 2-3 notices, my lord, whereby I have been asked to appear for cross-examining the witnesses. That is going on. I have filed an additional affidavit, my lord, today. After the filing of
this extract of the inquiry is a part of the findings of the department.
No, my lord, either as it may, I am entitled to a full, complete inquiry report, my lord.
No, where this does not.
No, I am on a different aspect, my lord. It was a factual narration. Now, my lord, after inquiry report has been submitted, now I have been given an opportunity to cross-examine the witness.
Where do you get?
Yes, I have filed an additional affidavit, my lord. Page 71.
71.
Page 70 onwards, my lord. Page 70.
0. Yes, please.
Kindly see, my lord. On 18/9, it was given. Regarding cross-examine the witnesses by delinquent in connection with DP number so and so. Then, my lord, will kindly come to page 71. Please direct Monirul Haq, the complainant, my lord, so and so, to appear before the undersigned on so and so for cross-examination in connection with. Am I clear, my lord? Then, my lord, will kindly come to the next page.
No, see, if the disciplinary proceeding is satisfied that the points you are trying to raise in your reply to the second show cause notice is sustainable.
Yes.
He may say that
no,
can,
no,
but,
but
but that way he cannot rely upon the inquiry.
Exactly.
Is he relying upon the inquiry?
Yes.
Where?
That's why, my lord, they're relying on the inquiry report. That's why I'm on, my lord.
That means
Please come to the impugn order, my lord.
Are you trying to make out a case that this aspect of giving you a scope of cross-examination is a mere formality because
mere formality? They've already made out your mind. Kindly see, my lord.
No,
kindly see page 64, the impugn order.
64.
Yes, of the writ petition. You are hereby informed that inquiry into the charge frame against you has completed.
Yes.
A copy of the inquiry report is enclosed.
Yes.
Peruse the findings submitted by inquiry report, submitted wherein she substantiates the charges against you. Charges which have been posed are very serious and unforgivable nature. That is a demand and acceptance of bribe money from member of public. For this, you were arrested by so and so. Hence, you were awarded major punishment of dismissal. You are thereby required to show cause, if any, against the action proposed to be taken, any representation which you may file. That means, my lord, based on the inquiry report, which is yet to attain finality, my lord, they want to take an impugn action of dismissing me from service. That's why this second show cause notice has been taken.
Lordship, the events in the
The sequence of things are not proper. This
Lordship,
second show cause notice is 38/2023.
Yes.
Where you have asked him to show cause against the proposed penalty. That is not required under 42nd Amendment.
not
Yes.
But
penalty,
nonetheless, let us have it in another perspective that let us presume the second show cause notice in the normal sense.
Lordship.
But then also, after this show cause, you have asked on 29/2023 that he can process them. Where is the scope now?
Basically, he had given a representation. What your Lordship had initially stated, he had given a representation, and from what it appears, the disciplinary authority is trying to cure the irregularities in the process, your Lordship. So this is what is happening, your Lordship. From what seems to be the
Mr. Property, we are Hadarika, we are not saying that you're without any powers or something. You have a procedure. You can say that this kind of inquiry we are not accepting. You have the inquiry first, give him an opportunity of cross-examination, come up properly, then we'll examine.
Yes.
Now, he has already taken a decision that we are also proposed to dismiss you. Then we see that there are WT messages giving him chance to process them. Where is this book now?
it seems to be correct. Now, of course, it cannot be that the earlier
No,
penalty.
he could have said, no, we are not accepting this inquiry report. Go back.
De novo.
Do you have an inquiry? Because at least from this stage, when he'll be given a chance to process them.
At least it vindicates our stand that Rule 9 was violated. He was not given the opportunity of cross-examining.
Normally, disciplinary proceeding case at the motion case, we not interfere. We examine. But here, first we can judge another senior counsel.
H. Ahmed, my
For the Ahmed. Conflict. The petitioner who was working as a sub-inspector of police at the Bilasipara police station was accused in a complaint registered as ACB PSK number 39 of 2023 under section 7 A of the Prevention of Corruption Act. The petitioner was also arrested and later on released on bail. Consequently, the petitioner was suspended by an order dated 29/5/2023, followed by initiation of a disciplinary proceeding by show cause notice dated 16/6/2023. The disciplinary proceeding had proceeded by holding an inquiry which was forwarded to the petitioner by check and show cause notice dated 38/2023, whereby the disciplinary authority had also proposed imposition of a measure punishment of dismissal from service. Petitioner has submitted that the inquiry itself was a flawed one, wherein the delinquent petitioner was not given scope to cross-examine the witness. By referring to the addition affidavit filed with the petitioner today, attention of this court has been drawn to the annexures which constitute WT message of dated 29/2020, by which the petitioner has been directed to appear no, has been was directed to appear on 21/9/2020 for cross-examination. The as the Chaudhary Jalan contains that it becomes apparent that only a formality has been thought to be done, whereby substantial justice has been wholly overlooked. That notice be issued returnable by 6 weeks. We see as Sadarika State Council accept notice on behalf of all respondents.
No, Your Lordship, 1,
1,
2,
2, 1, 2, and 3.
4 will
Let step let extra copy by tomorrow. That step be taken for service of notice upon the response of court by registered post date. Step by tomorrow. The Chaudhary Jalan Council praise for an interim order. Do normally, this occurred in exercise of it, and while examining a case of disciplinary proceeding is loath in interpreting at the interim case in the instant case, the impugn action appears to prima facie illegal, whereby the petitioner, whereby only a formality has been done as a foot of done. It is seen that while the disciplinary authority by the communication dated 38/2020 has already come to a conclusion of guilt of the petitioner and had also indicated the proposed penalty of dismissal from service, the further action of giving the petitioner a scope of cross-examination does not appear to be reasonable at all. In that view of the matter, till the returnable date, the disciplinary authority cannot proceed with the matter of imposition of penalty to the petition pursuant a communication dated 38.
Deep breath. Oblige.
May I please go on? Petitioner has come up with a very innocuous prayer, Your Lord. She is presently working under the respondent authority, Your Lordship, as scientific officer under 3 Act, Your Lordship. That was a pursuant to an advertisement and selection, Your Lordship. If Your Lordship comes to page 24, an advertisement was issued, Your Lord.
Yes.
Page 24, Your Lordship, is the advertisement for regular recruitment, Your Lord. And here, Your Lordship, what has happened? Your Lordship will come to page 29.
Your application for
Is
case
pending.
is going to yes,
Lord.
go ahead.
That is pending, Your Lordship.
Take instruction. We'll have it on Monday next.
Lord.
Or based on your instruction, we'll heard as what have put under count for the petition. So the petitioner is working as
Scientific officer, Your
a
Lordship.
scientific officer in the Directorate of Forensic Science, Assam, to which he was inducted by uh, the, being appointed under Regulation 3F
3F, Your Lordship.
of the APS. The state post, however, is being thought to be filled up on a regular basis, in which the petitioner would is aspiring to compete. However, the petitioner would petitioner has become overage
By 47.
by 47 days as on the date of submission of the application. And in this regard, he has submitted a representation to the personnel department
Lordship.
in terms of government notice 35/1991 for concerning the age. However, no action has been taken. We should be attended. That we are allowed to have some instruction as the matter can dispose of the motion of this case Monday next.
Monday is
Tuesday.
Tuesday, Your Lordship. Because 7th is the last day.
On third.
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 On 3/10. That extra copy of Mr. You also have some rules?
Deeply obliged.
You are for APS? Keep it up, and it counts.
My brother, I am appearing in item numbers 25 and 26. Lordship, I am praying for a short accommodation for the day. Lordship, unfortunately, the rules of 1985, the copy which we have, are far from being legible, Lordship. Therefore, Lordship, for
Rules
preparing
of
1985, Lordship, Assam Forensic Science Laboratory Service Rules 1985. Those are far
These
from.
are old matters.
Lordship, a short accommodation of a week, Lordship, for preparation of the type copies, Lordship, next week, any day. Because the rules
Yes,
are.
yes, what do you say? Copy and doctor, for whom? APS. Do you have an extra copy of this rule? Share with your colleague. Give the photocopy. Anyone has?
85 of I have the rules, but those are.
No, they may have a better copy. Do you have a copy of this rule?
The original to 1985.
So these matters are been wrong. The age of property. But now, very petition. Given for obtain a fair copy of the what rule?
Lordship, Assam Forensic Science Laboratory Service Rules 1985. 85.
You have a copy.
I'll obtain.
Also heard. That also heard Akuti for irrigation department. No,
Lordship, here respondent number 1, 2, 3, and 4.
no, which is the department?
Forensic.
Forensic science department. If you have the book, please on Tuesday next.
I am for item number 24.
And they go 24.
Much obliged.
On Tuesday next.
Lordship.
Yes, but it is
May it please your lordship. Lordship, these petitions were for appointment of arbitrator, lordship. Lordship, we have instructions to withdraw these petitions as by Honorable Supreme Court's order dated 21/8/23, arbitrator has been appointed, your lordship.
These
you
are
have a copy.
Yes, your lord.
What is your name, madam?
M. Kakuti.
You're on record. Yes. MSM Kakuti, Senate Council for the petitioner. In these cases, submit that do is was for appointment of arbitrator. The Honorable Supreme Court by an order between 8 has already appointed an arbitrator to adjudicate the dispute. The effort that has been
that is already on record now.
effort that the submission has been endorsed by each and sending council railways and madam for
Yes, Dr.
for
I'm for.
I mean, 27th is in 28 and 29.
S. Chakraborty.
Yes.
Both by MS B. Sharma and MS S. Chakraborty Senate Council for the rate. In view of the above, the petitions are closed. Do you have a copy, extra copy of this?
Yes, sir.
A copy of the order date
That-
21/8/2023 main part.
That is already on record, my lord, that's communicated by the Honorable Apex.
Lordship, in attendance 24-27, Lordship, can it be on Thursday, Lordship?
Yes, who was on the other side?
Will inform it. Council for FSL.
Fifth.
On
Fifth.
5th, Lordship.
Who was there? Yes,
The Council for the forensic science.
Mr. Kakuti was.
I will
Please
inform.
inform.
Lordship,
Highly obliged. Yes, Mr. Bharat.
It is Lordship. Lordship, on the last occasion when the matter was heard, service is complete on response number 4 and 5. Affidavit needs to be filed, your Lordship. This matter has been filed for a simple cause of
Yes, who's there?
implementation of the rules.
Affidavit not yet filed.
Not yet filed, your Lordship.
Yes,
Yes.
Sutya. Chakraborty, Sutya, what is this?
126. Yes, 120.
The notice was issued
Notice issued, your Lordship.
February 2022.
And on 19/7/2023, your Lordship, it was stated that response number 4 and 5 have also been served. So
Yes.
it's effectively.
Where are your instructions, your affidavit?
The 4 and 7. The matter pertains to only approval on the rules, your Lordship, because so as to grant the petition.
At least get the instructions.
No.
Get the instructions. Part
1 and 2 and 3.
them. However, please some more type of instruction. Sarah. Keeping consider the fair time is granted. No. While granting 2 weeks time to obtain instruction, consider relief frame. It is observed that an endeavor be for disposal of the writ at Yes. Good.
Going forward for time, the government support approval of second thing.
The Kakuti, what is this?
Maybe Lordship. Lordship, there is a development in this writ petition, Lordship. The petitioner number 1 has already been promoted on by the order dated 19 July 2023.
Okay. How many of the one of the two petitions?
There are 2 petitioners. I am giving Lordship a copy of that order.
Now, what is your
So I am remaining for the petitioner number 2. So on last occasion, the respondent has sought time
Yes,
for
affidavit
filing-
filed or not? Three, D. Kakuti, Learned Counsel, that during the pendency of this case, the petition number one has been promoted
Item number two.
to the post of junior by the order 19/7, and therefore the Kripa would remain free for the number two.
Yes, only petition number 2 remains.
The para. Tuesday, Learned Assistant Record. This and none. See with further text of it. Yes, what is this?
Look, we can start at 2 below, subject to your lordship convenience. It may take a little time. This relates to that IIT. Once your lordship also had occasion to deal with it. The director of the IIT was not appointed to some other post, therefore a vacancy arose. So there is a procedure
Yes, yes, yes.
for appointment.
Yes, but madam,
Kindly take up this matter at 2.
2 o'clock.
I think they will.
Now we may not have time. Why is it remaining? I think we made a long time back.
I don't know. We're running against time now.
That was in June. Advance the 26th and 27th September. This is for the regular.
Yes.
Now we are at the point of acting. Acting.
Acting. In charge. In charge, and also, my lord, the governor,
Now who's running the show?
that acting. There was no interim order was not passed by this court.
Acting who's the acting now?
IR, one professor IR. Respondent 5. He is acting. And
Okay, we'll have it at 2.
at 2. That will be better.
We'll try to finish up this matter.
Yeah.
My lord, item number 32, instead of me, my lord, Soduri will appear our text, my lord. SK, text. Soduri, he Soduri, my lord. We are not afraid.
जी का कुछ sir, 3 weeks. Yes.
No. This matter, my lord, there are 2 aspects. One is the appointment of a in charge or officiating director. And the other is, my lord, participation of the respondents 4 in the selection of the new director. Regular director, my lord. whether he should participate or not in view of some of the facts which I am going to place. Well, in IIT, Guwahati, the director, Mr. Sitaraman, he was appointed elsewhere as a director.
The Artful director.
Artful director.
What was his name?
Mr. Sitaraman. He was appointed as the director of AICT. AICT. So a vacancy arose. And then the question arose as to how do you fill that vacancy? The IIT Act or the rules, do not have any specific provision with regard to the officiating appointment of a director. That your lordship will find only in the first resolution of the council, which took place on 52, my lord. May 25th of May 1962 at page 22.
Yes.
The first meeting of the Indian Institute of Technology Council was held in New Delhi on Friday, 25th May 62, and Humayun Kabir, B.C. Roy, and all that. As far as the officiating part is concerned, your lordship may turn to page 25.
22,562.
25,562, which your lordship will get at page 22. The
Yes.
meeting,
Yes.
first meeting of the Indian Institute of
Yes,
Technology.
yes.
There, these resolutions were taken, one of which is, my lord, concerning the officiating appointment, which is at page 25, my lord, item number 7. The second part, my lord.
Yes.
In the case of short-term vacancies or appointment as an officiating basis, pending selection as per above procedure, the chairman of the council should make the appointment in consultation with the chairman of the concerned board of governors. Chairman of the council means, my lord, the parent council of all India basis, the minister education of the central government. And governor means, my lord, each IIT has a board of directors and he is called the governor, the chairman. So the import of this is the chairman of the council should make the appointment in consultation with the chairman of the concerned board of governors. That's the requirement. Now, in this case, my lord, it's really a case of 3 emails. I'll go from the affidavit of the Union of India itself. Reply of respondents 1, 2, and 6. This is mirrored at page 61. Annexure C. This is the first email of the Board of Governors
whose name is Milord R. Modi, Cadila Pharma and all that, which your lordship will get at page 61 at the top. Response number 1.6. Bigger response. Response number 1.6. 120. And annexes C thereof. Yes, annexes C at page 61. Page 61, Milord. Chapter 69. Annexes C, Milord. Page 61. Three number is 95. Doesn't matter. We have. Oh, I see. I am sorry. Doesn't matter. Doesn't matter. It is an email of 28th of. The old practice has been restored. I'm happy. 20th of November 2022. 20th of November we have 22. We have. Yes. Yes. Now, this is the Milord first email to the Secretary Higher Education, that is Rakesh Ranjan, on 20th of November 22 to the Secretary Higher Education, Ministry of Education, Government of India, copy to Additional Secretary Higher Education. In pursuance
Who
of...
is this?
Beg your pardon?
R.I. Modi, who is this?
He is the governor of the IIT Guwahati.
He's the chairman
He is the chairman
of Board of Governors
Board of Governors
of IIT Guwahati.
of IIT Guwahati. So this is his email to the Secretary Higher Education, Ministry of Education, with copy to the Additional Secretary Higher Education, Ministry of Education.
Please read this.
In pursuance of the letter dated 17 November 22 of Department of Higher Education, Ministry of Education, Government of India, Professor T.Z. Sitaraman, Director IIT Guwahati, who is appointed as Chairman AICTE, may be relieved from his duties from IIT Guwahati in early December 22. Next paragraph is important. As per the statutes of IIT Guwahati, I, as Chairman of the Board of Governors, appoint Professor P.K. Iyer as Director in charge of IIT Guwahati until further orders, and entrust the charge of the Director in charge of IIT Guwahati to Professor P.K. Iyer with effect from 9th December 22. Professor P.
Mr. Iyer is a respondent here.
Yes, yes. He is respondent number 5. He is a professor, and in the list of professors, his position is 59. So this gentleman, governor, he thinks he has the power under the statutes to appoint as in charge, and therefore he is picking up the 59th man from the list of professors. And as per the statutes of IIT Guwahati, I, as Chairman of the Board of Governors, appoint Professor P.K. Iyer as Director in charge of IIT Guwahati until further orders, and entrust the charge of the Director in charge of IIT Guwahati to Professor P.K. Iyer with effect from 9 December 22. T.G. Sitaraman, Director, may be relieved on 9 December so as to allow him to report to AICT as Chairman. Yeah. So this is the first email. The reply, Your Lordships, kindly turn to 63. Overlooking the first and second, Milord, the third. That is the reply. No, it no. It no. I'm sorry, military, it is the second year. Huh? Just a minute, give me a minute. 72, I think. Reply by Ranjan. Yes. Page 72, Milord, if your lordship kindly turn. The screen number is 106. 106. I'm sorry. Doesn't matter. Sorry. Reply. Reply. Here your lordship will have both. Yes. The second one is the last one of that page. From Rakesh Ranjan, he is replying to the first email which your lordship has just seen at page 61. And this is Rakesh Ranjan, that is the secretary, Milord, and date is 21st November 22 to Rajiv Modi, copy to Sanjay Murthy, another officer. Subject IIT relieving so. And if you turn over the page, this is his letter from the secretary. Dear Dr. Modi, at page 73. Yes. Thank you so much for taking time off your busy schedule and sending the recommendation for the charge arrangement for the position of the director IIT Guwahati in this connection. Following further details may kindly be sent. One is Professor IIT senior most. If not, any reason for not recommending the names of any of those who are senior to him? Seniority list of faculty members of IIT Guwahati and details of faculty members holding senior administrative positions, deans and deputy director. Details may be kindly sent at the earliest so that the recommendation could be submitted to Honorable Minister of Education in his capacity as chairman of the IIT Council for a decision. Now, this is the reply of the secretary that send us the details and all that, whether he is senior and all that. And this reply, your lordships now kindly turn to page 72. Earlier. This is the reply of the Governor Modi. This is the third email. It is sent to Rajiv from Rajiv Modi in November 21st. He sent in the morning and he sent in the afternoon. And then hello again. He is younger, so this is his reply. He is younger, energetic, and has many accomplishments to his credit, as sent as attachment in my earlier email message to you all. The other seniors had been reviewed by me, and in my judgment, they would
Luckily, he has not written brown hair. Luckily, he has not written he has got brown hair. Young, energetic.
He is younger, energetic, yes. Correct, Virat. And the second paragraph, kindly see, the other seniors.
But he must be having blue eyes.
Blue-eyed, obviously, because otherwise you don't pick up 59
No, literally.
from the list of professors.
No, there may be some reason.
On the day when he was appointed, he was not even completing 10 years as professor, which is the requirement which I will show in the advertisement for the regular post.
This is the second part. The other seniors had been reviewed by me, and in my judgment, they would not be able to carry on with the momentum of upgradation that we have had at IIT Guwahati in the past years. Professor Iyer has been involved in many ways in the development of IIT Guwahati during the time of previous director as well as during the tenure of Professor Sitaraman. So he will enable smooth transition. Thank you for your understanding.
This particular gentleman, Dr. Rajiv Modi,
Yes,
what is his antecedent? He is connected with Cadila Pharma.
yes.
What is how is he the chairman on what capacity?
He
He's an academician.
He is appointed as the governor.
No, is he an
of-
academician?
As an industrialist.
No, he's doctor.
Doctor maybe, Milord, I don't know. What kind of doctor, God knows.
No, is he an academician?
Maybe.
Just as of curiosity, we are asking.
Maybe he is managing director of Cadila.
Cadila.
Pharmaceutical company.
He's managing director.
Maybe, Milord. No? Over paisa lagi. So this is the process.
No, why we are asking? Because he says that he has reviewed the seniors. To make a review, one needs to be sound academically. He is reviewing professors of IIT.
IIT review for 58 professors he has reviewed and 59 he is giving in a matter of one day. Wonderful.
Then what happened? Thereafter,
This is his reply. And then, my lord, the letter comes appointing him as the in charge.
Where?
Yes. That is annexure 2. Page.
Of your petition.
Yes.
Page 30.
Page 30. A copy of the letter of 2012. This is from my lord, this is from Modi, Rakesh Ranjan to Dr. Modi. Secretary, Additional Secretary, Technical Education, IITs, Government of India. Dear Dr. Modi, please refer to email dated 2011-22 addressed to the Secretary, Ministry of Education, forwarding therewith the letter dated 19/11/22 of Professor T.G. Sitaraman, Director IIT Guwahati, regarding acceptance of his resignation as early as possible to enable him to take up the position of Chairman, All India Council for Education, Technical Education, AICT, New Delhi. In this connection, it has been decided, with the approval of the Honorable President of India, in her capacity as visitor of IIT Guwahati.
Next paragraph, you can come to paragraph
3. It has also been decided with the with the approval of the Honorable Minister of Education, in his capacity as chairperson, IIT Council, and Professor T. Sitaraman may hand over the charge of the post of Director IIT Guwahati to Professor P.K. Iyer, Department of Chemistry, IIT Guwahati, who will act as officiating director, IIT Guwahati, till regular incumbents takes over, or till further orders, whichever is earlier. You may like to take further necessary action in this regard. So, And then he mirrored Annexure 3, next page, joining report of PK Roy, PK IR on 2012-22. And page 31, next page. This page 30 later is 20th December, and 31 is also 20th December. And this is joining report of the PKI. So therefore, my lord, the first email itself proceeds on the footing that the governor has the power under the statutes of IIT to appoint a officiating director, and he directs that he is appointing Professor Iyer to officiate as director. Now, whether that is legally permissible. The page 25, I have shown your lordship the procedure prescribed for the purpose of officiating appointments at page 25. In the case of short-term vacancies or appointment on officiating basis pending selection as per above procedure, the chairman of the council should make the appointment in consultation with the chairman of the concerned board of governors. Your emphasis is, my lord, the appointing authority is the chairman. He initiates and then he consults the governor for the officiating appointment. That's how I understand this, and that's the only way to understand it. What has been done is, the gentleman concerned, the governor, he thinks that he has the power under the statute, which he says in his first email, that he has the power to appoint, and therefore he is appointing Iyer as officiating chairman. So, on the face of it, the appointment of Professor Iyer as officiating director is official. It doesn't get cured by the letter of appointment, which says that after, with the approval of the president or the visitor, and he is appointed. That doesn't cure the initial, my lord, infirmity which has been revealed by the first email, namely the gentleman concerned thinks that under the statute he has the power to appoint an officiating chairman, and he appoints. And then everything turns upside down. Normally the minister concerned as chairman is to consult him. Now he appoints, the governor appoints, and the final appointment later comes, which only suggests that in consultation with the government. But actually, from these letters, it is absolutely clear that the governor was under an impression that under the IIT statute, he has that power, can he appoint, and that gentleman again is now being appointed with the approval of the government. So that is the first. And as far as, my lord, the options in IIT, so far as, my lord, officiating appointments are concerned, if your lordship, we have said that at page 6, my lord. Of the writ petition. Page 6 of our petition, Miller. Paragraph 4. That the first part really is a reproduction of that which I have already read out at page 25. In the past, the second page, in the past, the following options have been used by Minister Education, Government of India as chairperson of IIT Council. 1, to ask the deputy director if in position to take over the charge. The petitioner incidentally is the deputy director, is a regular deputy director appointed under the IIT Act. So the first option is if you have a deputy director, you can think of him as an officiating director. The second thing is the senior-most professor of the institute or the senior-most professor if the senior-most is not willing or is not found suitable. Third is, director of any other IIT to shoulder the additional responsibility.
You are a deputy director.
Bigger department.
You are a deputy director.
Yes, I am a professor, and also, under the Act, there is a post of deputy director, and I am a regularly appointed deputy director.
This past practice is based on any documentary documents or
deputy director is under the Act.
Mr. Goswami,
Yes.
the options which you have stated in paragraph 4, these are based on what? The past practices, these statements are based on some record.
RTI reply also is there. I'll draw your lordship's kind attention. I think in one of the affidavits we have mentioned that. The same options are given.
These are not disputed.
No. Nobody has disputed. This IIT Act, Institute of Technology Act 1961, I think my lord has got a copy. Section 17 deals with director. And paragraph 18, section 18 is deputy director. The Section 18, Miller, deputy director.
IIT Act of 19.
Page 15 of that book. The deputy director of each institute shall be page 15 of that book, Miller. Section 18.
Yes.
17 is director, 18 is deputy director. Deputy director of each institute shall be appointed on such terms and conditions as may be laid down by the statute and shall exercise such powers and perform such duties as may be assigned to him by this act or the statute or by the director. So I am a deputy director appointed under section 18 and a regularly appointed director. In fact, my lord, in our reply, my lord was asking me about that 3 options.
Yes, yes.
That is mentioned also in our reply, in affidavit in reply to the affidavit in opposition of the Union of India, namely respondents 1, 2, and 6. At paragraph 4, page 3 of that affidavit. Your reply. Yes. To the affidavit in opposition of respondents 1, 2, and 6. Yes. Paragraph 4 at page 3. RTI. Yes, RTI's reply we have set out. Has come to learn about the reply by dated 27 to 20 from the Undersecretary to Government of India to queries made in an application under RTI 2005, wherein it was stated that in the past, while making, acting, or officiating directorship, the following three options were used by the IIT Council to ask the Deputy Director, if in position, to take over the charge. 2. The senior-most professor of the institute or the next senior professor, if the senior-most is not willing or is not found suitable, or the director of any other IIT to shoulder the additional responsibility. So, the settled procedure 462 resolution as well as the prevailing practice is that you first, if you have a deputy director, you appoint him, or the senior-most professor, or if he is not willing or not suitable, the next senior. But seniority is maintained, that's the whole purpose. And because it's a officiating promotion, they don't want to disturb anything. Or get somebody from another director from another IIT to fill up the gap. So that was the fact. Therefore, my lord, the appointment in the instant case, which was made, as is absolutely clear from the language of the first email, the governor thinks he is having the power under the is absolutely without jurisdiction. And to legitimize it by appointment subsequently from the secretary taking approval of the thing does not meet the real requirement, because the chairman has to initiate. Here you are not only initiating, you are thinking that you have the power and you are appointing. And the central government is now towing the line to have it approved. And kindly see now in the affidavit itself, the outgoing Milord, the director, Sitaraman, he has sent, kindly turn to page 64 of that Government Union of India affidavit, reply of 1 to 6. He has sent this to the Secretary of that your lordship will find at page 64. Yes. From director to Rakesh Ranjan, please attest posted first list of professors of IIT Guwahati. So he is sending him as he wanted that list in his second email, which your lordship has seen. Our name at page 65, serial number 22. Mechanical engineering professor, and state from which he is pulled. And then below the entire list is there. Page 66 is 59. Serial 59 is Parameshwar IR. Chemistry professor from 13.
Yes.
So it's a long list of professors they have. Which, it ends at page 71.
Yes.
There are altogether, I think, 197 professors. And this is his recommendation. In the list, Professor P.K. Iyer, I am reading at page 71, where the list ends. In the list, Professor P.K. Iyer is at serial 59. May kindly be seen serial number 14, 48, 47, 106. Has vigilance inquiry cases. That is, we are not concerned, but page 71. Yes. After the list ends,
yes.
This is,
Yeah,
yes. He is now indicating that some of the professors are having some vigilance inquiry. Some of the senior professors may not be interested or not good with R&D. Deans, senior and DD, 2 resumes have been attached. So he is making the recommendation. Please find attached 2 resumes of senior faculty from Deans stroke DD at Deputy Director at IITZ for Director in Charge position, along with my comments. 2 CVs attached along with strengths and weaknesses. So he is first recommending Professor, long name, T. Punyamurthy, serial 26, Dean of Faculty Affairs and Professor of Chemistry, CV attached, 68 years. Strength, Fellow of 3 prestigious academies in India and good publication record with good mix of administration, academic profile, and good qualities. Good number of guidance of PhD students, within bracket 41, and good number of research projects. Good planning and selection of faculty at IIT Guwahati. Created good document for awarding best faculty and implemented successfully HAZ professor promotion. Good exposure to outside university. 2, Professor Sushindra Kumar Kakoti, that is the petitioner, age 62, serial number 22, Department of Mechanical Engineering, strength presently Deputy Director for last 2 years, and earlier Dean Infra and Planning, long experience, 34 years in various institutes, local SMEs, for good understanding of finance and work hard with regard. So these were the 2 recommendations sent. By the outgoing director, Milan. Him on 21/11/22 before leaving. So for in charge Miller, he was suggesting these 2 names. It is not known as to, they don't say anything about this in their affidavit as to what they did about these recommendations, because possibly they were already having an appointment order through an email from the governor, and they were pleased to go along the line of the governor. So this is so far as the appointment of the officiating director is concerned. This is entirely contrary to the resolution, first resolution, and also the recommendations of the outgoing director and the established prefect. Therefore, this is an appointment which should really be settled. It's not just merely below the question of one IIT. These IITs have created a name for India in outside world also. A lot of these graduates are manning those important posts, and a lot of students from outside also come because of the standard of education. And if we let this kind of a thing creep in, it just opens the floodgate in a way, because if you just open it and depart from the established convention and the established resolution, and over the years, the way things have been going, it doesn't, it's not a very healthy sign for these institutions. So this is therefore we are saying that at least it should be declared that this is not permissible course of action, and this should have been not followed. And therefore this appointment should go. The second issue is this, the regular appointment advertisement has come that your lordship will get at page 33 of the writ petition. When it was issued is not very clear, but the last date for filing of the application was 28/2/23. Yes. Applications are invited for appointment to the post of Director of Indian Institute of Technology, Guwahati. Director of an IIT is the academic and administrative head of the institution. She is expected to have a minimum of 5 years administrative experience and leadership qualities to head an institute of national importance. The candidate stroke person should be a PhD with first class or equivalent at the preceding degree, preferably in a branch of engineering. In exceptional cases, candidates with science, mathematics, or management degrees may be considered. So basic thing is below the branch of engineering, and only in exceptional cases below this departure will take place. She should have an outstanding academic record throughout and a minimum of 10 years teaching experience as a professor in a reputed engineering or technology institute or university, and should have guided PhD students. The applicant should preferably be less than 60 years of age. On the last date of receipt of the application, the post carries a fixed pay of so and so. Guwahati IIT is an autonomous institution fully funded by Ministry of Education. And that's what you can keep. So the last date is mentioned at page 34, 28/2/20. Now, for appointment of a director, under the Act, section 31, I'm sorry, section 17. Section 17, at page 15, Miller. The director of each institute shall be appointed by the council with the prior approval of the visitor. The director shall be the principal academic and executive officer and shall be responsible for administration and all that below. Then Miller, the by the council, this council is section 31. At page 22 of that book. With effect from such date as the central government may by notification in the official gazette specify in this behalf, there shall be established a central body to be called the council. The council shall consist of the following members, namely the minister in charge of the technical education in the central government, ex officio as chairman, the chairman of each institute as ex officio, the director of each institute as ex officio. So this director is a part of the Miller Council for the purpose of appointment of a director under section 17. Chairman of each institute as ex officio, the director of each institute ex officio, the chairman, University Grants Commission, Director General of Council of Scientific and Industrial Research, chairman of the Council of Indian Institutes of Bangalore. All these are there. 3 persons to be nominated by the central government, 1 to represent the ministry and all that below. The composition is prescribed under section 31. So, my lord, the regular appointment of the director under section 17 will be by the council, of which, my lord, the governor of IIT Guwahati is a member. Therefore, the question is, if he has already formed an opinion as disclosed in the first email that and the second email of his, saying that I have already reviewed all the senior professors and that they are not up to the mark. Then, my lord, should he take part in the proceedings for selection of the regular director? That's the question. If you have already judged their qualifications and the abilities and say that they are not fit enough even for officiating appointment, now how do you want that person to be a neutral, fair member in the composition of the council to appoint the director for this institute? Because I'm sure there will be applicants. There is at least a recommendation of the outgoing director, in respect of 2 of the persons. One is the present petition, and the other is one of the professors. But there may be others also who will be applying, for the post. Should he, take part in the proceeding? Or would it attract the principle of fair play and nature?
This particular respondent number 5 is he doesn't have engineering background.
No, he's a professor of
Professor of chemistry.
chemistry, and he was a dean, public relations and ranking, branding and ranking. And his position, as your lordship has seen, is 59th as a professor. The advertisement for the regular director really contemplates that in exceptional cases only you should go for non-engineering candidates.
The arrangement on officiating this is a different chapter.
Yeah.
And the regular appointment is a different chapter.
Different.
Regular appointment would be governed by the advertisement case study, which says that incumbent has to come from a branch of engineering. Only in exceptional circumstances you can consider somebody who is a professor of science, math, or management. So
and also some period
other
for administrative
some other
experience and all.
So here's the observation, the compensation of the chairman of the board of governors, so far as in charge was concerned, will it play any role for the election and appointment for regular appointment?
No, normally may not.
Why we are saying? Because this advertisement has got nothing to do with charge arrangement.
Correct, brother. Normally your lordship will be right. But his second email, which is without a reply.
No, that reply was in the context of teacher.
True. But he has said that I have reviewed all the professors.
But he doesn't even come to the ambit of selection. He comes to the second category. That under exceptional circumstances, you can take an academician who is not having an engineering background.
No, I'm not on that. I'm saying that what is the import of his reply to the secretary? First email is his saying that I have the power under the statute, I appoint so and so.
Yes.
The secretary, by the second email, inquires, is he the senior most?
Yes.
What about the others? Have you considered? You sent us the list and all that. The third, again, is the governor's reply to that, saying, I have considered all of them. And they are not suitable for officiating
Now,
promotion.
first, what we have understood, there is no absolute not
So,
provided what we hear from the other side.
yes,
But so far as your second leg of argument, second other challenge is concerned,
yes,
regarding his role, the
his
role of the
participation
in the
in the process of selecting the regular director, would it not affect the principle of bias? If you have prejudged the abilities of these seniors, suppose some of them must have applied, and he is there, he will definitely go by his own assessment, which he has put it on record, that he doesn't consider them fit enough to be officiating directors. And what is his standard? He is mentioned. He is younger, energetic, and has many accomplishments. The other seniors has been reviewed by me, and in my judgment, they would not be able to carry on with the momentum of upgradation, for God knows what that means, that we have had at the IIT Guwahati in the recent years. So this is the problem of his participation, at least so far as these applicants are concerned. Even for the entire process, Because he is reviewing 197 professors and then picks up the 59th man, or at least 58 professors, and in the same day the message comes. Therefore, my lord, this is a question which is the second part. Should he take part in the process of selection of the director? Generally, irrespective of who the applicant is, in any case, as far as the applicant of this institute, if they have applied. It is extraordinary, my lord. You have these IITs have, their record is such and standard is such that it is quite a surprise to know that 58 people of this IIT is not fit enough for officiating appointment. And if you go by the advertisement, 10 years is the experience. On the day you are appointing him as officiating, he has not fulfilled 10 years also. No, I am only saying, normally the appointment and the advertisement for appointment at page 33. 33. A minimum of 10 years teaching experience as a professor for a regular. Where do you get? Yes. Not in the at page 33. Yes. There are two things. Primarily, it is branch of engineering, and secondly, administrative experience plus the minimum of 10 years. So it is admitted by him in his affidavit that he didn't fulfill, but by the time this application comes, he fulfilled. That may be so. And it is doubtful about his minimum 5 years administrative experience. Till that. He has already prejudged the quality and ability of this. At least 58 he has. Where did you submit that not have minimum 10 years teaching experience that we have in that affidavit. That's an admitted position, will it? I'll just give a lot to the.
Just
Yes,
get the page.
yes, I'll just try to get. Hmm? No, we have said that somewhere. Hmm? No. If your lordship see the list of professors, I think it is clear from that only. We
So
need
that
not-
was given by the outgoing.
Yes, yes, because that is that page. Date of joining is given, you know. Yes, Union of India's affidavit, that list of professors.
105.
Yes. At page 66, his serial is 59, and the date of professor, which your lordship finds at the beginning, page 64, last column. These dates which are given, that is the date of professor, joining of professor. And so far he is concerned, it is 28/1/13. So he fulfills 10 years in 27 January 23. And when he is appointed, it is less than 10 years. He is appointed in December. Okay. He is one. Hmm.
Yes. But so far as the regular advertisement for regular director is concerned, that advertisement last date was 28/2023.
By that time, he was fulfilled. I am only indicating.
As a deputy director.
I am only indicating that see the situation, and that you are overlooking 58 and picking up somebody who is on that particular point of time, not even 10 years of experience. That indicates a certain amount of bias in his favor. And it's not it is by one person, that governor. It's not a council's decision.
Yes, anything else?
Yes. This prejudging part, I'll just from GSP Judicial Review of Administrative Action.
Which book are
this is GSP Judicial Review of Administrative Action, 4th edition.
Yes.
Page 285, Miller.
You can photocopy it.
I'll give that. Your lordship may just note the page.
Yes,
Page
285.
285. The relevant principles formulated by the court may be broadly summarized as follows. The authority in which a discretion is vested can be compelled to exercise that discretion, but not to exercise it in any particular manner. In general, a discretion must be exercised only by the authority to which it is committed. That authority must genuinely address itself to the matter before it. It must not act under the dictation of another body or disable itself. This is the part I am relying. Or disable itself from exercising a discretion in each individual case. The fact that he has given that email stating that I have reviewed the cases of all these persons and they are not fit enough to whatever his language is. By this period, he has foreclosed his mind. He has prejudged the ability that these people are not even fit for officiating appointment. This is where the problem is arising. His own actions, first of all, first email itself, assuming a power. Second, comes from the secretary, his third, and he is saying that I am reviewed them. So he has foreclosed his mind so far as the merits of these persons are concerned. And disabled himself, disqualified himself in the process from sitting in a body who will be selecting a regular director. One more passage, Milord, you also may note the page. I'll give it, Milord, page 169 of the same book. What happens, Milord, if the mind gets closed? Last 4 lines of that page, Milord, 169. Provided that a properly conducted inquiry had been held, the only grounds of challenge could be that the minister had not in fact considered the report or the objections, or that his mind was so foreclosed that he gave no genuine consideration to them. He can't. We have to take a practical view of his assertions in the email. 169 or 52. On that disabling part, while summarizing, my lord, in that Khudiram case, and Justice Bhagavati judgment AR 75, Supreme Court 550, there are 10. para 9, my lord. Yes, was indicating in this paragraph on what grounds judicial review is permissible, even in a discretionary exercise. I'm not troubling your lordship with the various other grounds he has mentioned there. And so also would the exercise of the power be vitiated where the authority has disabled itself from applying its mind to the facts of each individual case by self-created rules of policy or in any other manner. This is in paragraph 9. Para 9 middle, Miller. After that reference to that 52 Supreme Court 16. Yes. Disabling oneself, Miller, by a view which prevents you from, in normal human circumstances, Miller, to change or give a fair consideration at a later stage. And this part is also discussed in a detailed judgment, which this is mirror 2013, volume 16, Supreme Court cases 116. All this natural justice bias, everything is being discussed. Paragraph? I'll just give you lordship the paragraph. First paragraph is 34. Cryback has been. Yes, it refers to Carpac. Therefore, I'm not citing Cryback. Para 34 at page 26. The fundamental principles of natural justice are ingrained in the decision-making process to prevent miscarriage of justice. It is applicable to administrative inquiries and administrative proceedings as has been held in AK Parpai. It is also a fundamental facet of the principles of natural justice that in the case of quasi-judicial proceedings, the authority empowered to decide the dispute between the contesting parties has to be free from bias. When the free from bias is mentioned, it means there should be absence of conscious or unconscious prejudice to either of the parties, and the state principle has been laid down in Nageswara's case also. I keep the lordship can just have a look at page paragraph 37 also. At this juncture, this part is also mirrored just before 37. Eventually in the state decision in Surana, it has been ruled that what has to be seen in a case where there is an allegation of bias in respect of a member of an administrative board or body is whether there is a reasonable ground for believing that he was likely to have been biased. That's the test. Is disclosure in the email of his review of the entire lot of professors, whether this can introduce an element of bias. That's the test. And it says you may be a member of an administrative board or body, whether there is a reasonable ground for believing that he was likely to have been biased. Nobody can x-ray the inside of the brain, Miller. It's a reasonable possibility that you will logical ground and a reasonable man's test.
His role was explicit in selecting a particular individual
Correct.
for the post of
Correct. And then 37. At this juncture, we may refer with probably to Halsbury's laws of England, where it has been observed want of impartiality or bias fraud. The test for bias is whether a reasonable, intelligent man, fully apprised of all the circumstances, would feel a serious apprehension of bias. That's the test. Somebody may not going from this institute as an applicant, after coming to know of these observations of the governor, would he be feeling safe that as a member he will not try to influence others about what he thinks about these people? Will not? That's the test. A predisposed, para 38. In transport versus so-and-so, while dealing with the concept of bias as a part of natural justice, this court observed that, then it is quoted, a predisposition to decide for or against one party without proper regard to the true merits of the dispute is bias. That's the thing. There must be reasonable apprehension of that predisposition. The reasonable apprehension must be based on chosen materials. The material is very obvious. It is his own word. You don't have to look for anything else. I don't trouble your lordship with everything else. Then paragraph 59. He discusses all these cases. Here, Milord, some of the officers made some comments. They did not collect the materials, but the materials were given to them and they observed certain things. And the question is, if one of them remains in a committee, whether that will introduce a sense of bias. That is how the problem was arising. And at page 59, after referring to the facts of that case, last paragraph, on a bare perusal of the same, one can easily say that the technical members have expressed their opinion after analysis of the documents. They have in detail scrutinized the documents, drawn their inferences, and made their observations. This document has been marked as exhibit so and so. By no stretch of imagination can it be said that it is an arrangement of documents or pagination of documents. True it is, they are not the authors of the original documents, but their analysis and inference have been used against the respondents in the earlier court of inquiry and in the additional court of inquiry. It cannot be brushed aside by saying that the technical members did not sign the final report. Once they have given an opinion, the possibility to support the same cannot be totally discarded. That's the normal human instinct, my lord. That is where the real likelihood of bias comes into play. That's the point. Then next paragraph below, it is quoting another case. So it is said that in judging a question of prejudice, court must act with a broad vision.
Which paragraph?
The very next paragraph, 60, my lord. They have quoted from another judgment of the Supreme Court. The issue also requires to be examined on the touchstone of doctrine of prejudice, as unless in a given situation the aggrieved makes out a case of prejudice or injustice, some infraction of law would not vitiate the order and inquiry result. In judging a question of prejudice, the court must act with broad vision and look to the substance and not the technicality. That's the test. Ultimately, it is what was said in 1927, I think, no? Lord Hewitt, that justice should not only be done, but it must be manifestly seen to be done. This is another case, 98 5 SCC 513.
I want 3.
513. The same thing I was looking for, at page 526, para 32. The above magazine has also the other principle based on the most frequently quoted dictum of Lord Hewitt, in sense so that it is of fundamental importance that justice should not only be done, but should be manifestly and undoubtedly be seen to be done. Bias, as pointed out earlier, is a condition of mind, and therefore it may not always be possible to furnish actual proof of bias. But the courts, for this reason, cannot be said to be in a crippled state. There are many ways to discover bias, for example, by evaluating the facts and circumstances of the case, or applying the test of real likelihood of bias or reasonable suspicion of bias. This Smith's review of administrative action, the pages I have already shown you, Lordship, 262 and 264, has explained the reasonable suspicion test looks mainly to outward appearances, while real likelihood test focuses on court's own evaluation of the possible probability. Hmm? Hmm? Network number eight. Hmm. The recent one is from Calcutta, where my lord, the learned judge of the High Court gave some interview or something, and the matter was brought to the notice of the Supreme Court, and the Supreme Court said that directed the Chief Justice to change the roster and take it away from him. That came out in the paper. That judgment has also.
Justice Ganguly.
I think somebody.
He said
That is very recent. This is, I think.
the subject was presiding, some comments were given.
Justice Ganguly. Ganguly.
Ganguly, I think some Ganguly, na? Huh? Uh-huh.
Yes.
Hmm.
Abhishek Gangapathy.
Yes, yes, yes. So they didn't say anything much, but they said that directed the Chief Justice to take off the matter from the charge concern. To continue. Sabai local and Google. The call was 2013 department. Hmm? Hmm? Okay. Oh, working. Hmm? Okay. Yes. এটা কথা হতো। I think Hmm? And in their affidavit also, my lord, Government of India has not said anything about the recommendations given by the outgoing. What happened to them or what they have done about it, there is no reply at all. The whole thing is, my lord, that the view expressed is going to affect the future or the career of those who are applying, and that's the reason why this gentleman should not take part. He has already given his views. How to ask him? Yes, because full collection. We are told, my lord, My learned friend was,
Yes, we have that. Tomorrow,
yes,
tomorrow, 26, 27.
26 and 27. Therefore, the Honorable High Court may kindly be apprised that the matter regarding selection of regular director IIT is at an advanced stage, and the selection committee meeting is being held on 26th and 27th September 23. So, that is the present position, my lord. So, some interim arrangement has to be taken, because if he takes part, my lord, then it might restrict the whole thing. And this order of 26/6/23, another single judge has said, my lord, will order to copy. This is an order passed by Justice Suman Sham on 26/6/23, because the prayer for interim order will also be considered on the next date fixed. It is hereby made clear that if any interview is conducted in the meantime for selection of candidates as IIT Director by a board constituted with the respondent number 4 as one of the members, the outcome of the process will be subject to further orders that may be passed in this case. That was an order passed, but it was on 26th June. Now we have now take fully argued the matter. Therefore, I will pray that I will have two prayers. At least whatever the result, at least we have said at page 13, that there should be at least a declaration that this kind of departure from the existing norm is harmful, and therefore it should not act as a precedent, because that is necessary for the future of these good institutions that we have said in our writ petition. I think it is at page 13. Yes, that's it. Yes. So that is one part. The second part is, my lord, his participation. Your lordship should make it very clear that it will not be proper for him to participate after his thing, that or they should postpone the meeting till your lordship decides the matter. No, we are deciding. Yes, that's what I'm saying. So it may take a little time. Tomorrow they are going to hold the meeting. I don't know what for, or if election is going to take place tomorrow itself. All these questions will be there. Therefore, the lordship will have to take. So whatever is possible, we'll hear from them. There we can get more. If you have something, we can like hear the IIT. Yes, I have something.
Wait, Peter.
What is it?
Basically, 2 points has been argued. Yes. Since my learned friend has dealt in detail, so I'll, my lord, not repeat the argument. 2 points have been argued.
Chaudhary, you are for whom?
I am for respondent number 3 and 4. 4 by name.
Three is
The chairman of the board of governors.
3 is who?
Against whom, my lord, all the allegations.
R3
are 3 and 4.
3 is whom?
3 is the chairman in the official capacity,
Okay.
and 4 is by name.
By name. This Modi. R. Modi.
Dr. Modi. My lord, he is a doctorate in biotechnology, my lord. He is also a pass out from IIT Mumbai. And my lord, he had his post-graduation from America. And of course, my lord, he is a renowned industrialist and he is the chairman of the board of governors. Now, my lord, 2 points has been urged. The first point is the manner in which, my lord, respondent number 5 was selected as an in-charge director. That is, my lord, dehors the statute. Now, my learned friend has not brought your lordship's notice one thing. If your lordship would kindly come to page 25. This is the first, I think, my lord, resolution of the IIT, sometimes in 1950s. Please come to page 25.
62.
Come on, 25, read it.
No, 62, 1962.
62, yes, yes. I'm sorry. Yes. Please come to page 25.
Yes.
The council decided that for the regular
Item
appointment,
7.
item number 5, Roman 5, 7, yes, 7. Here, I was 6, 8, yes, 7. The council decided that for regular appointment of to the post, it should be advertised by a selection committee consisting of the chairman of the council as chairman and the chairman of the concerned board of governors, chairman of the University Grants Commission, one expert to be nominated by chairman of the council as member. Now, this is regarding regular. Now, my lord will kindly come to this subpara.
Yes.
In case of short-term vacancies or appointment on officiating basis, pending selection as per the above procedure, chairman of the council should be made, should make the appointment in consultation with the chairman of the concerned board of governors. Now, the procedure is, my lord, when it comes to appointing and short-term, I mean, yes, then it is the chairman of the, my lord, council would make the appointment on the, in consultation with chairman of the concerned board of governors. Now, in this case, lordship has seen by the first mail, the respondent number 3, he recommended, he never appointed, my lord, because the argument, yes. If we take the affidavit of our respondent number 1, 2, and 6, page number 61. In pursuance of the letter dated 17 November 22 of the Department of Higher Education, yes, page 61.
Yes.
In pursuance of the letter number dated 17 November 22 of the Department of Higher Education, Minister of Education, Government of India, Professor T.G. Sitaraman, Director IIT, who is appointed as Chairman AICTE, may be relieved from his duties from IIT Guwahati in early December 22. As per statute from IIT Guwahati, I, as Chairman of the Board of Governors, appoint Professor P.K. Iyer as Director in charge IIT Guwahati until further order and entrust the charge of Director in charge of IIT Guwahati to Professor Iyer with the kindly mark the date 9th of December 22. And my lord, it was sent on 28th of November 2022. My lord, it was a recommendation. Now it is the chairman of the council, that is the Minister of State in the higher education, who is the competent authority. It was his recommendation, my lord. Professor Sitaraman may be relieved from 9th of. The idea was, my lord, since Mr. Sitaraman has already been appointed as chairman of the AICTE by the Government of India, therefore he should be relieved from his duties with effect from 9th of December. Simultaneously, my lord, based on the recommendation, if he is appointed, he should be appointed, given charge from 9th of December. Now, page 71, 2, my learned friend has already referred, my lord. There is a query from the Ministry, my lord, secretary, as to how come you have preferred this gentleman, why not others? Now he says,
Page
page 72, my lord, of the affidavit. Sorry, 73. 73. Is Professor Iyer the senior most? If not, any reason for not recommending names of any of those who are senior to him? Seniority list of faculty members in IIT Guwahati and details of faculty member holding senior administrative position, as per example, Dean and Deputy Director. Incidentally, my lord, respondent number 5 is the senior most Dean. Huh? Presently, he is the senior most Dean, my lord. He has filed an affidavit where he has explained that position. He is the senior most Dean, my lord. Now, my lord, Mr. Modi, the chairman of the board of governors, my lord, he replies at page 72. He is younger, energetic, and has many accomplishments to his credit, as sent as attachment in my earlier email sent to you all. The other seniors have been reviewed by me, and in my judgment, they would not be able to carry out the momentous upgradation that we have had in IIT Guwahati in the past year. Professor Iyer has been involved in many ways in development of IIT Guwahati during the time of previous director as well as during tenure of the Professor Sitaraman. So he will enable a smooth transition. So my lord, he has his reasons for saying, and eventually this was accepted.
Just a minute.
Yes.
You had just said that respondent number 5 is the senior most Dean.
Dean, yes.
But that was not a consideration of Mr. Modi while replying to this query.
No, my lord, what I am saying is, because one of the queries from the...
This may be an additional factor,
Yes.
but that was not in the mind of Mr. Modi while making the reply.
So Modi, my lord...
He says that he is younger,
My lord-
energetic, and many accomplished.
My
He
lord,
just said,
I would respectfully submit, my lord, this observation of Mr. Modi at page 72, this is subjective, but my lord, he makes his subjective satisfaction based on some objective material. Objective materials are indicated. This satisfaction is subjective. But my lord, these are all based on objective material, who will also include the material that he is the senior most, my lord, dean amongst the dean of the IIT.
so whether that was taken into consideration by Dr. Modi,
Which one, my lord?
that he was the senior most.
Naturally, my lord, the matter was laid before him when the, my lord, decision was...
Revelation has been made by you.
Yes. No, my lord, from the pleadings it transpired that Mr. Iyer is the senior most dean.
Something which has come up later, can it be a relevant factor at the time? of
No, my lord,
consideration?
Lordship will kindly see, this was a part-time arrangement.
Correct.
It was only a part-time arrangement. Whether, my lord, there was a semblance of application of mine to the, my lord, relevant, requirement. It was a part-time, my lord. I'm not saying, my lord, the board of governor enjoys absolute discretion. No.
Even if we accept your argument, that was also one of the objective standards by which we have come to a satisfaction.
Yes.
But what about all persons, including 2 resumes, which were also forwarded by the outgoing director?
My lord, let us test that argument. My learned friend is relying upon the recommendation of the then director. There also he has superseded so many. What is his answer to that?
No, there are 2 resumes.
Yes, I'm referring to those only.
No, the others have not given resumes.
Huh?
There were no other resumes. There are 2.
No, my lord.
And he's the second most. There is one person above him also.
No, my lord will kindly come to page number 65. Page number 65.
Yes.
Serial number 22 is Professor Procedural Kumar Kakoti, that is the petitioner.
Yes.
And serial number 26, Professor Tharmalingam Twenso. These are the 2 persons who were recommended by my lord, the then director, on the eve of his appointment as my lord, director AICT. My lord, even in his case also, he has superseded so many persons.
No, come to page 71.
Yes. Yes, I'm coming to that only, my lord.
Please find attached two resumes. These are the two resumes which were placed for him.
Exactly, I'm saying, my
One
lord.
is one at serial number 26. One is at serial number 22.
Yes, these are the two persons. Serial number 22 is the petitioner.
Yes, understood. There were no other resumes.
No. What I'm saying is, my lord, these are the recommendation of the then director Sitharaman.
No, Sitharaman has also taken the name of Professor Iyer. Just above it. At serial number 69, maybe may kindly be said.
Yes.
Then he finds there are two resumes. Dean Senior, two resumes have been. These two resumes have been forwarded.
No, in the list, PK Iyer is there. He's at serial 59. Then 14, 46, 47, 105, they have got vigilance inquiry. Some senior may not be interested or not good with RD. Dean Senior and DD, two resumes have been attached. These are the two resumes. And maybe this may be, that part, my lord, I think government will able to, explain, my lord, because it was eventually the decision was taken at the level of the, my lord, government.
If we go a plain reading of the list and the content of email given by the outgoing director,
he
has not recommended anything. He has just placed everything for the council.
Yes.
That this is the list. We can add, you can see, he's at 59. I do not know why. Thereafter, he says that there we have also received two resumes. These are the resumes. He has not said.
In fact, my lord, other than respondent number 5, there were 6 applicants from the, IIT Guwahati.
For this,
No, for the regular. Apart from petitioner, there are 6 applicants from Guwahati.
No, for regular, for the advertisement, we are not very now considered.
Yes.
Advertisement comes later.
Yes.
It is in last date was 28th of February 2023.
Yes.
But this mail, which we are now concerned, is of November.
Yes.
2022.
21/11/22.
So that question at that point of time, the question of submitting regular application did not even come.
No, my lord. Oh, yes.
Obviously, it cannot come.
Yes. No, my lord. The fact of the matter is, amongst others, the resume of these people were there.
Yes. Amongst others, you cannot introduce.
Yes.
Amongst others, that clause part you cannot. Not reflected.
No, what I'm saying is, my lord, now eventually on what material the recommendation of my recommendation was accepted by the authority, that the records will reveal, my of the government of India. That the main decision was taken by the chairman of the council. That is the MOS.
Correct.
I only recommended by that first email of 2011.
Which you say that it was only a recommendation, not an appointment.
No, certainly not. It was a recommendation. By all means, it was a recommendation, my lord. Because, my lord, the procedure is spelled out in the first resolution of the IIT board.
62.
Page 25.
1962.
1962. It says the appointment, and in our affidavit, that's our clear stand, my lord. Please have a look at our.
There is no dispute.
Yes. So therefore, my lord, since it was an provisional appointment, and all that is required to be seen is whether there was some requirement envisaged which has been followed or not. When it comes to the regular appointment, certainly Lordship will apply this strictest of the norm. Whether it was fair, whether it was transparent, whether any element of bias has crept in, everything, Lord. But as far as
isn't it the law that the eligibility criteria which are normally meant for a regular appointment should, as far as applicable, be also made looked into while making temporary. That is the law. If you are having a candidate who fulfills the requirement eligibility of a normal recruitment, why do you ignore him and have somebody who does not even come into the MP?
No, my lord, I would respectfully submit these positions, director of IIT, etc., These are not promotional posts, my lord. These are all selection. Here, my lord, merit is the first criteria. If somebody has got a better merit, he has to be selected.
No,
there is no service
no,
rule, my lord, which
but,
says
but to come with the zone of consideration, you need to have in a certain position. A newcomer who has not even completed 10 years, he cannot say that I will consider me for director.
no, my lord.
No doubt it's a merit.
As a professor, he was short by few days. That is 10 years. But otherwise, my lord, he's he's a brilliant. He's an exceptional one. That's why, my lord, is.
Then no, even if we for just a testing, 10 years, but it's a temporary arrangement. 10 years records we may not be that much.
Some
strict.
liberal
We may
approach
not be
can be
very
adopted.
rigid. But what about he doesn't come from engineering background.
Who, my lord?
This particular gentleman.
No.
Higher.
Higher is from engineering background, my lord.
He's a professor in English, chemistry. Yes. He's a professor in chemistry.
No. Kindly have a look at this, my lord.
Come to the list.
Yes.
At 59. He is a professor in chemistry.
Candidate person should be a PhD with first class or equivalent at the preceding degree, preferably in the branch of engineering. In exceptional cases, candidate with science, mathematics, or management degrees may be considered.
That is it.
He should have been an outstanding academic record throughout and a minimum of 10 years teaching experience, a professor in a reputed engineering or a technology or university, and should have guided PhD students.
Correct.
Yes.
So if there are no persons with engineering background, then exceptional circumstances, you come to a person who is
otherwise falls in that category.
When there are persons, doesn't look slightly.
No, my lord, my submission would be when it comes to selection for the, provisional part, there, my lord, some element of discretion may be there. But only thing is whether that discretion which has been exercised is an unfettered discretion, or while exercising that discretion, my lord, due regard was had to the norm.
But is justice being done to the system to be not only the client of Mr. Gupta, to all the aspiring candidates? I might think that I am having engineering background. I am fulfilling, I am in the cadre. You select somebody. If I was not there, you select him. No issue.
No, my lord, my regarding my lord regular selection, tomorrow if Mr. Iyer is not selected, end of the matter.
Even before that,
No, I'm just pointing out.
Your client is the chairman of the board of governors.
No, my lord. The constitution lordship has seen.
Yes.
I'm only a member, my lord.
Yes, no, you're chairman of the board of directors.
Yes.
As a chairman
Board of governor of the IIT.
Sorry, board of governors.
Yes.
And
by virtue of that, I'm a member of the selection committee.
So you become a part of the selection committee.
Yes.
You become a part of the council.
Now, my lord will see, Minister of Education is the chairperson. Then one TV Narendran is the member. Then my lord BVR Mohan Reddy, he is another member. Then of course me, Rajiv I Modi. Then Dr. K. Radhakrishnan, Chairman BOG IIT Kanpur and Chairman Standing Committee of the so-and-so. Then two other special invitees are there, my lord. K. Sanjay Murthy, Secretary, Higher Education, is a special invitee, and MS Sumaya Gupta, Joint Secretary, Technical Education, Minister will serve as a non-member secretary of the committee. So, my lord, apart from the minister, there are 5 others, which of course includes the present, the client whom we represent. Now, my lord, it is not that, my lord, the end of the day, when it comes to bias, it has to be seen in the fact of each case. No general law can be, applied in all cases, my lord, uniformly. Now, not. No. My lord, lordship will see nothing has been brought on record to show that he will have any role in the main selection qua the respondent number 5. If that would have been brought, my lord, then there is a question of real likelihood of fight. So very. My presence, because in the earlier occasion I recommended his name.
That was for my lord temporary. That was not for regular position.
No, not temporary, but determined to be younger, energetic. Even for temporary now,
My lord, my humble submission would be
no, if
when
it is
it
done by
when it
support, if
well, it has the apprehension has to be, my lord, very I mean more, but it can't be mere apprehension. It has to be a pronounced one. Now, what material has been brought on record to suggest that my presence will, I mean, tilt the scale in favor of, I mean, respondent number 5? Nothing has been brought on record other than to say that while recommending his name for the temporary position, that's all. The bias has to be real bias. I'm also relying on one or two Supreme Court judgments, my lord. It says it has to be real, not one pretended one. My lord, I am relying on 2008 12 SCC 230. 2008 12 SCC 230, paragraph 7. I'll hand over the copy, my lord.
Name.
Para 7.
What is the name?
Name is, my lord, Cantonment Executive Officer and another versus Vijay Diwani. 2008 12 SCC 230, para 7. The question of bias is always a question of fact. The court has to be vigilant while applying the principle of bias, as it primarily depends on facts of each case. Court should only act on real bias, not merely on likelihood of bias. Now, my lord, my learned friend referred to one of the judgments where in a court of inquiry, my lord, certain persons took part in the proceedings. Now, court of inquiry is nothing but a fact-finding exercise. If a person is involved in the court fact-finding exercise and he has expressed his opinion, then naturally, my lord, there is a likelihood of bias. Because eventually, my lord, based on the fact-finding inquiry, charges will be framed and those will be proved during the court-martial. But here in this case, where are those materials, my lord? Only for the temporary position, I recommended his name. There's no dispute about it. That by itself, it will disable me from taking part in future selection of regular, my lord. In my humble submission, my lord, it will be too much of a stretching of the principle of bias. That is an aspect, whether somebody is with engineering background. Those are the matters which will be taken note of, my lord, when it comes to regular selection. Naturally, my lord, when there will be more persons with engineering background, I respectfully feel, my lord, Mr. Iyer may not figure in that list. No, my lord, my humble submission is, as far as the
Professor Iyer is not a contender in the main.
No, he has applied. As I submitted, apart from Mr. Iyer, 6 other from Guwahati IIT had applied, which also includes the petitioner, my.
Total 6.
6. 8. Huh? 8. Oh, including Iyer 8.
Total 8.
Including Iyer and the petitioner. And my lord, will it be not too much to say, had it been a case where he would have been the lone person to make selection, then things would have been different. There are ministers, there are other directors from other, chairmen from the other IITs, my lord.
Mr. Chaudhary, in Kraipa's case, he had recused. Yes. But in spite of that, he said that even if you have recused, the influence which you can have will always be there.
My lord, those are cases where people set very high standard. But my lord, when it comes to, my lord, end of the day, what is the judicially manageable yardstick to measure it?
the end
You
of
were,
the day,
you were
yes,
right.
my
You
lord,
may
if
be right in
somebody,
considering those standards were different. Now
yes,
standards.
somebody having regard to the, my lord, I mean, propriety and other aspects, my lord, maintain a high standard in public life, those days are gone, my lord. Let us be very clear about it. Nevertheless, it is not my submission that one should
No,
not
the,
inculcate those.
nowadays the necessity is also there.
Yes.
The,
Then nowadays, my lord, doctrine of necessity comes in. Anyway, that's not the case here. So my only submission is, my lord, merely because I recommended Mr. Respondent number 5 name for the in charge position, that necessarily may not lead to the conclusion that I will have a bias to select. And that too by a committee which comprises of 6 other persons apart from me. It is in that context, Lordships will have to see the likelihood of real bias. And my lord, the applicants are 300 in number. People from abroad have also applied. It's not only 8%, 300 applicants
8 from Guwahati.
for Guwahati.
There are others also.
300, my lord, 300 plus applications across the globe.
Which are only 8 left.
No.
Total 300.
More than 300.
Tomorrow you are having the selection. Tomorrow and day after.
Tomorrow and day after. 26 আছে 26 আর 27
Tomorrow and day after. If none of you are selected,
And my lord, Lordship will kindly appreciate one more thing, my lord.
in
My
the
lord,
selection tomorrow day after, neither you nor respondent 5 is selected. Then
no, my lord, my humble submission is, if your Lordship will eventually have a look at the order, his recommendation, he says this for this transitory period. The last word is very important, my lord. Page 72. So he will enable smooth transition. So all that he meant was, until a regular director comes in, to enable smooth transition, he would be in a better position. And when those remarks were made, those were not really on merit, my lord. That was just for the making an assessment on the, I mean, transitory phase, my lord. Those observations were there.
can it be on a personal satisfaction?
My lord.
Even for transitional post, traditional post, can it be on the basis of personal satisfaction that I am satisfied, he is energetic? Is it not required to be based on some objective standard that if there is a testing by the public, not by the court?
My lord, the manner in which,
I
my
like
lord,
somebody, I appoint him.
no, the manner
It's not
in which
something in my home.
it could have been, the language could have been better. Perhaps that was not the intention. Having regard to the interest of the institute, somebody felt maybe for this interim,
that is why the
interim
institute
period.
Institute is none but the IIT, where the highest of standard needs to be followed.
Yes, certainly.
Public, matter of public perception.
Anyway, my lord, now eventually, after tomorrow and after will be the selection. Maybe within 15-20 days, results will be out. Another 1 month, new director will be there. So, my lord, as far as in charge party is concerned, is as good as it is over. Plus, my lord, his tenure as deputy director is also over now in July. In the petitioner's tenure as deputy director, that is over. That does not decide it. So, my lord, therefore, to
You
sum
have
up,
rightly advised the other side. Because if bring in this thing, we'll be bad. You have produced the document. It is not really in good taste. Because this consideration will be on that point of time when he was holding deputy director. Now he is gone. So that consideration we have. It seems that you are against this particular person. Why?
anyway, my lord, therefore, to sum up my argument, my lord, as far as the in charge part is concerned, that part is almost over. Now, my lord, final selection is going to be made. Now, number one, if Mr. Nair is not elected, then my lord, entire edifice of the petitioner's case falls through. Secondly, my lord, as I have already submitted, the recommendation of respondent number 3 in favor of respondent number 5 for the temporary or in charge appointment, that necessarily cannot lead to the formation of an opinion or a belief, or as a prudent, normally prudent person, that there could be an element of bias when it comes to final selection. Because for that, my lord, some materials are missing. Those chosen materials are not there. That by itself cannot constitute a chosen material. Unlike in that case where, my lord, in the court of inquiry, the man took part, then, my lord, charges were framed. Naturally, my lord, if the charges were framed by him and if he becomes the judge, naturally, my lord, there is an element of bias. Here he is not the only person. There are 6 other members, minister is there, other chairmen from the other IITs are there, government nominees are there, everybody will play a crucial role. And my lord, I'm sure when it comes to IITs and all, government will not favor any blue-eyed boy, my lord. They will go by sheer merit. That's why, my lord, these institutions are growing. And my lord, yes, I do agree, my lord, that the recommendation of his could have been worded in a better way. That's a different thing. But then, my lord, the intention was, my lord, what was, prior in the mind of the respondent number 3 was the interest of the institution. Maybe he failed, my lord. Under Sitaraman also he has done some good work. So let him continue for that interim period. Because that is to be followed by regular selection. So that being the position, my lord, I think it will be premature, my lord, to take a call of bias at this stage, my lord. It will be highly premature, my lord. It's better, my lord, the lordships gives a quietus to this case, my lord. And if a lordship feels that there are any shortcomings, or a lordship can always, form of an advice, it can be said, my lord. If anything is, if a lordship felt that there is any action on our part, it's not, in keeping with the high tradition, that we'll correct ourselves, my lord. But then there is no element of malice or anything, my lord. The primary consideration is the interest of the institution. And that's why, my lord, these institutions are growing. That being the matter, my lord, I don't think, my lord, any case has been made out for interference.
I for IIT Guwahati.
For
IIT Guwahati, question number 7.
7.
Lord.
And who is for 5? 5.
Initially I advocated for 5, Lordship, when IIT was not a party in this case, but subsequently IIT Guwahati was considered as a party. And I have got the permission of the court, I have withdrawn myself from the respondent number 5.
Who is appearing for respondent number 5 now?
Now no one is appearing. He simply filed an affidavit that was there in the record.
Affidavit through whom?
If respondent number 5 filed an affidavit in this matter, but after I have withdrawn, he has not engaged anybody.
Affidavit in opposition has been filed by 5 and 7. Common affidavit.
No, 5 has filed an affidavit, Lordship. Not common. At page 35, Lordship. Page 35, no? Page 35. And here,
by Mr. Sutradhar.
the Lordship, Sutradhar has filed it. That time we were there for 5, but once IIT is made a party,
No. 7 is by 7 is below IIT's affidavit. IIT was made a party subsequently. And IR is respondent number 5. He has also filed an affidavit.
Now, but nobody is representing IR.
He was, my friend was there, then possibly.
Now no one is
thought,
representing him.
uh,
Is there any order?
Yes, yes, there was an order. He undertook not to appear. And he has not chosen to engage anyone else. See? Yeah. There is an order, my lord, which is at page. This is 26/6/23 order. That is mentioned there.
We'll do one thing. We'll have, we'll continue this tomorrow, Mr. Sami.
Yes, sir.
Would you like to hear it?
Lord.
Huh? Here is firefighter, side of an order. If your lordship, if he has finished, I have 15 minutes, I can finish it.
No, we'd like to hear. Then you'll come back and come. Are you here tomorrow?
Yes, yes, I am
Then
here.
let him finish.
Oh, yes, yes.
You can give a common reply then.
Yes, yes. I thought he has also.
No, he's not started.
He was waiting for IIT, which is no.
In fact, very late to go.
You don't have any rule.
No, I make submission, but since I appear for IIT. Let it be tomorrow, Lord, we will make submission. Short up.
IIT is the chairman or chairman is the IIT.
Chairman is the Lordship.
It seems the chairman is much above the IIT.
Definitely.
IIT is definitely.
Definitely.
What are you saying?
Chairman is very above the IIT.
Chairman is above the institution. Kakuti, what are you saying in this court?
No, Lordship, that IIT is represented by its registrar and head
You
of the
said the
IIT.
chairman is above the institution.
No.
Who's the chairman?
Chairman is the
He's a mere individual.
chairman of the board of governors.
Tomorrow he's not the chairman.
No,
IIT is going to stay for here forever.
no, board of governors is the Lordship appointing
We
authority.
think that there is some problem in this matter. Serious problem. That is the perception of the senior council holding the brief for IIT. The chairman is above you. Then we have serious.
Not in that way above us, but
And
the
in what
chairman-
way? We are asked a very particular question.
He's chairman of the board
Who's
of
the
governors.
chairman?
It's a board
Is
of
he
governors.
somebody who is above the institution?
No, board of governors, Lordship. That runs an institute and he's the chairman of the board of governors.
Somebody runs the institute, but can they be above the institute?
That way cannot, Lordship, but he's the one who appoints, Lordship, the board of, he's the head of the board of governors. And board of governors,
Okay, we'll
Lordship,
continue tomorrow.
Lord.
First it. Third. As well. Okay, so, select on. Accepted. On number 4. Both the learners have concluded their activity are understanding who appears on number
7.
7. However, could not start it at before. Consider back. Please change for 40 years. That's the first thing. We are retaining this book.
Yes, yes.
And Mr. Chaudhary had referred to one judgment 2008, 12. Please give a copy.
I'll provide a copy.
And other matters where interim order is still today, any matters, interim order needs to be extended. Otherwise, dates will be given by court martial. Sir, ask anything?
Doctor, item number 45 may kindly be taken up day after tomorrow.
No, no,
because
he'll
there's-
keep dates. Dates will not, depends on the fact. Any matter where interim order is still today.